Supplementary list 1 pertaining to visual bench, item number 1.
My first suggestion would be that the holding of the letter dated 17/4/2021 as an order under section 3Z of the Act is an error apparent on the face of the report.
Because it was not an award.
It was not an order as contemplated. It
It was not an award.
was not an award.
In terms with section 3G,
G.
3G1.
What? It is
Okay,
on,
where have you passed an award?
Malad, so far as this package is concerned, Malad, what happened, the entire road was divided into different part. So claim and objection on the part 1. Initially, they have taken note of it, they have solved it, and then thereafter, an order has been passed. That,
No, I am asking you, have you passed an award?
I am NHIDCL, it is the state government, the KALA, the authority, competent authority who would pass an order.
Now, has he passed the award? I'm asking.
To my knowledge, they have not passed.
So as of now, there is no award.
There's no award.
So therefore, there is no award.
There's no award.
So, but you have issued the 3D notification. Have you issued the 3D notification?
3D notification has been issued.
But 3D notification was issued when?
3D on 29/9/2020.
So the last 5 years, there is no notification, no award.
No award. Malad, not that, Malad. I said, Malad, they have taken a different parts. So far as a stretch of set of 2 kilometer or 5 kilometer, the objection of whatever is there at the part 1, they have passed an order.
And you have taken the possession
That is taken, Malad. That is
under
it.
3H without complying to 3H1.
We have paid the amount.
Now, how have you paid the amount without a computation being done?
Look, Malad,
If you say that there is no award,
Gotcha.
has there been an award? And therefore, my question is whether there is an award.
No, Malad, the award,
If
Malad,
there is no award, how did you pay?
because the moment we have approved, so we know how much we have to pay, and we are have to pay the amount. So we have deposited with the the competent authority.
So you have deposited with the competent authority
Right.
without there being an award.
Lordship, Malad.
How is it possible?
Because it was contemplated to.
Let's read 3H1. Read
Right.
3H1
Right.
and 3H2. Okay, National Highways.
Yes.
Yes, who is appearing for the respondents? The petitioners?
Yeah, I am on behalf of Mr. P.D. Nair, respondent number 1 to 6. He'll be hearing just another 2 to 3 minutes. He'll be hearing next 2 to 3 minutes.
Now let's see the order of the competent authority. Where it has been held that this is the amount.
Initially it was by the letter dated 17/4/21, seeking approval. We objected
Approval from whom?
from the competent from the central government.
Does the Act of 1956 provide anything to that effect?
My lord, this, my lord, so far as the procedure concerned, my lord, there is no such, my lord, prescribed in the act itself.
No, no.
But the ministry
Are
has,
you saying that the competent authority will do as per what the National Highway Authority will say? Maybe
no,
he's the agent.
reason is it?
He's an agent appointed under section 3.
Lord,
He may be the agent 3A.
Lord,
But the fact that he has an independent on the basis of the materials which is given in 3G 2 and 3, he has to do it. And thereupon, but when there is an order being passed, then that order will come within the ambit of 3G1.
yes,
Now, does the competent authority thereafter have the power to revise?
no,
No. So where is that order?
so there is no order.
Then there's no order. You have, for last 5 years, you have not passed an award.
Well, it is the, my lord, the
no,
competent authority that is.
No, we are not concerned with the
Right.
competent authority. Competent authority is a person where you have appointed.
It's the central government, we,
No.
Lord,
Central government. It is
And
being
what-
appointed by the central government through the Ministry of Transport.
Lord,
Then
Right.
he is appointed under 3A.
my lord,
Competent authority means any person or authority authorized by the central government by the notification in the official gazette to perform the functions of the competent authority for such area as may be specified in the notification.
my
So
lord, first,
without there being an order passed by the competent authority, how do you go to 3H1?
Lordship will, the first order under 3G1 has been passed, my lord, way back on 17/12/2020.
Where is that?
Well, that I have, my lord, brought on record by way of an additional affidavit dated 19/5/25.
Where is that page?
Page number 8. Lordship may come to my paragraph 5 onwards. Page 8, has your lordship got additional affidavit.
17th of December.
Lordship.
So this is the order.
This is the order only in respect of, my lord, a particular, my lord, portion with regard to certain claimant only, my lord.
Not
No.
in respect to others.
Not in respect to others. So the others were to be passed in part 2, part 3, etc. Now
Why-
we are concerned with the part 2, madam.
Now, Mr. Soike, why haven't you not enclosed the entire thing?
My lord, first,
Why you have enclosed only the order without the enclosures, annexures? Annexure 1, 2, 3, 4, page 10 you find.
lordship, madam.
Why you have not enclosed the
My
entire
lord,
thing?
my lord, basically, my lord, this is, my lord, with the, my lord, competent authority.
No.
Lordship.
Then only we will come to know what it is there.
Lordship, madam.
It is
My
insufficient.
lord, this page 10, your lordship may can receive, my lord. Page 10, paragraph 8, whereas the assessment was carried out but not yet completed due to shortage of expert concern and various complaints were required reassessment, assessment of building, etc. As the Chief Secretary, Government of Mizoram in video conferencing with NHIDCL and Deputy Commissioner held on so-and-so instructed DC Saitul to finalize 3G in clear cases in part 1, 264 cases out of 658 cases, and to deal with others, other lands in the next part. Now, therefore, in exercise of power conferred by Section 3G of the National Highway Act, the competent authority of land acquisition, Saitul district hereby determine the amount payable as compensation to be given to the 264 members of the landowners, interest parties out of 301 of the members assessed carry out so far in the part 1, as per details so and so, so and so. So these 264, there is no dispute, my lord, there's have been,
Now, whether the petition has come within the ambit of annexure 1 to 4,
my lord, this is the part 1.
are we concerned with part 1?
No, we are part 2.
So part 2, there is no award.
Part 2, there is no award. The approval was sought for on 17/10. For the part 1,
No,
for the part 2, my lord, I'm sorry.
no,
For the
Mr. Soikia, I am only concerned out here as to whether in respect to the award, in respect to the land belonging to the petitioners who are the appellants
Look.
before the score,
Look.
whether there is an order passed under 3G1. This is my specific question.
No,
No. So therefore, there is
But
no order being passed.
To our knowledge, no, my lord, it will be state government, they have to, my lord, if they have. My lord.
No, I'm not concerned with the
Yes,
state
No,
government.
no, because, my lord, the
It is
Kala, my
the
lord, I'm talking-
competent authority who has to pass it.
Yes, that is the
Now, who
competent
is
authority.
appealing for the competent
Competent
authority? Yes, who are these gentlemen appearing in video conference?
I am, my lord.
Oh, I'm sorry. Okay. So who is appearing for the state government? Kala.
My lord, the state government advocate is on legs.
Very well.
I'm informed she'll be here shortly.
Ask the the state government, the council who represents Kala, the competent authority of
Hello.
land acquisition in respect to the land which have been acquired out here
My lord.
in the present proceedings to be present.
My lord. my
Yes, Mr. Nair. But now, Mr. Nair, what is going on out here? He says that there is no award. Now, if there is no award out there, where is the question of acquisition? Yes, 3D they may take over, but they will be entitled to interest or everything out there.
In fact, on the basis of that 17/4/2021, my lord, they have already preferred an arbitration. That arbitration is pending. They have annexed the petitions,
Who has prepared an arm?
my lord, NHS. They have annexed
Where is the document?
My lord, this is from page 137.
137.
It's arbitration case number 1 of 2020. Filed on 3/12/2020.
Now, here they mentioned this to be a draft award. But where is the concept of a draft award?
There is none.
Draft award is foreign.
Yes,
As per this, it is the competent authority. And asking the competent authority of NHADCL to approve means the entire adjudicating process has been hijacked.
it's lordship is absent. In fact, there is no concept of approval other than National Highways Act.
No. So that is, and what did I pass the order to make the payment?
My lord, to make this.
Also to, my lord, liberty was given to approach the arbitration. So therefore, the arbitration was.
Where is my our
From-
directions?
From 126 to 126.
126.
The operative portion lordship will find at 125.
And Kala had revised it also on 18
My lord, that is what they are insisting on. They are insisting on payment as per 18. And in my humble submission, my lord, after passing the award, it becomes constitutional.
But this is where a single judge, our judgment is where.
This is from up to 136 is lordship's award.
No, this is not counted.
The single judges,
We have documented the impugned judgment suffers from no information. However, in view of the observations, we modify the judgment and demand thereby directing there to deposit the amount of compensation so determined in 12 so before the complaint at the earliest and not later than 30 days for the date of our judgment. We further direct there to disburse the amount of charge. What is wrong?
another 55 million. They are under review section. All these aspects, I don't document.
No, the question of there being an award is draft award, the concept of draft award is foreign. So the question he says now that there is no award of 17.4. There's no award, but there is an award by the very filing of the application by them under 3G5 shows that they have admitted there is a draft award. They say that that draft award is only a draft because of the fact that it requires the approval from the NICIDCL, which in the opinion of
That aspect, if I may, my lord, we have deposited the amount, my lord, annexure H to the review application from page, at page 112, my lord. We have deposited that. My lord, deposit is under 3H. 3H is pursuant to 3G. If that is so, they have accepted that it is an award, my lord.
so they have deposited in terms with
18.8. 18.8.
18.8, not
18,
74.
not- Because 17 has been revised 18.8. 17 has been revised
By
letter dated 18.
Kala.
By Kala, 18.8.
And learned single judge holds that 18.8 cannot just because
Yes, my lord.
the question
As
does not
because,
arise.
as because letter dated 17.4 has been taken to be an award. So after passing of the award, the Kala will not have an power of review.
Absolutely.
So that is the law, my lord.
We are also of the same opinion.
That is the law, my lord. There's no quarrel on it. But only thing is that whether it was an award, my lord, why, my lord, the writ petition was filed, your lordship will say the parties were litigating on a different, my lord, line. My lord. The challenge in the writ petition was basically to a letter dated 13/8/2021.
No. First of all,
There was no challenge
No,
to the-
Mr. Saikia, why are you not depositing the entire amount?
We have deposited, my lord.
As per 17.4.
Yes, my lord.
No,
look,
you
no,
deposit.
as per
No,
18.8.
Mr. Saik, why are you not depositing as per 17.4 and release the same? Get an order somehow. Either before the arbitrator, because the arbitration is done as per 356. Section 3G56, 3G6, as per the Arbitration and Conciliation Act. Now, if it is so, why you not taking a stay on that? Getting an interim measure out there before the arbitrator.
But because of the clear direction from this court, my lord, the arbitrator may not be, my lord, in a
No,
position.
we may make that clarity. You deposit.
Yeah.
And you will be at liberty to seek, because you comply with this direction, and you will be at liberty to seek appropriate the application for stay of that portion of that.
But so far as, my lord, Since.
But the fact remains that, you see, Mr. Thaika, the problem which happens, if we are to hold out here that there is a requirement of a further approval from NHI DCL, for the purpose of the award, the very edifice of the adjudication by the competent authority goes for a 6.
No, though, my lord, word has been used as an approval, my lord, what happened, my lord, under the act, there is no procedure prescribed in what manner, my lord, the Kala will, assess the, my lord, particular, my lord,
No,
Got
you don't require that.
Lordship. So, my lord,
Mr.
no,
No,
limited.
Mr. Saikia,
Lordship.
kindly see section 3G7. See, the procedure is given. And then see 2022 15 SCC page 1. The procedure is being given, whereby Supreme Court categorically says that these are to be taken exactly by taking into parameters of section 26 to 30 of the Right to Fair Compensation Act. Then
So, my lord, here, what is happening, my lord? In absence of the, my lord, as such procedure, my lord, the Ministry of, my lord, Road and Transport, they have formulated the guideline for, my lord, departmental concern, not for any other things, my lord. And there, my lord, it has been, in one clause, it has been said that we being the NHIDCL and the representative of the central government, we cannot be silent spectator.
no,
So
you are
therefore-
no, you cannot be the silent spectator is true. You have to be, because you have a right to challenge under 3G5. Challenge it. You have challenged it also.
So, my lord, that particular rule, my lord, it says, my lord, here, my lord, so that part I will come, my lord. My lord, here, the only limited role that has been given, otherwise the entire process NHIDCL doesn't have any role to play, my lord. The only, my lord, role that has been casted on us by this, my lord, manual in clause 1, that you cannot be a silent spectator because you are holding the central government public fund. So misuse you should see. And before the draft is, while the draft is made, you may seek for an draft award so that you point out the deficiency, if any, to the Kala. So that is the
No,
limited.
your
purpose.
participation may be very much there, because you see, if you see the judgment of the Supreme Court in another case of 1986, wherein it says that the competent authority acts as an agent of NHIDCL. So your agent has done this. If your agent have done this, if there is a fault of the part of the agent, therefore, unlike the Land Acquisition Act earlier, the reference here, you can seek a arbitration referral under 3G5. You are given the opportunity to file it. You have already filed it. Challenge it. Whatever may be. What is the outcome out there? But the fact remains that there is only one award or one order. The question of seeking any approval does not arise. So you take the advantage, deposit as per the direction, and ask request the arbitrator to pass appropriate orders under section 17 of the Arbitration Act.
My lord, here, before the arbitrator, we have to, my lord, seek, my lord, we have to say that this particular letter dated 17 is not an award.
No, you have to say, no, you cannot say that.
Yes, my lord.
No,
So-
you cannot say that. You have to say before the arbitrator that they have not taken into consideration section 12(4), which vests the minerals upon anybody, upon the government. So therefore, that is the basis for which we sought for an amended way out there. So this aspect, therefore, you don't pay this amount. And let us stay there. You have already mentioned in your application under section 3G5, why you are not appointing the arbitrator?
No, my lord, we have filed, my lord, the further, my lord, progress has not been possible any further.
Then,
My lord,
no
what-
case for review.
my lord, first, my lord, the.
We dismiss with a cost of 1 lakh each to petitioners for engaging Mr. PD Nair. How many petitioners are there?
6, man. 6.
6 lakhs.
Now, my lord,
This 6 lakhs cost may help you to go to Supreme Court.
they had been to the Supreme Court this.
Because Supreme Court is also aware of the fact.
And they
Because
have,
the concept, what you are asking for us is that this court has to say that there is a further award after the Kala Passan order. And
That-
you are
that-
you
what
are
I'm saying
asking
is
that the Kala be given a well. Yes, if the Kala passes an order, then just interdepartmental. it cannot be official also. It has to be in an interdepartmental proceeding that look at this is the amount we are thinking of giving like this and all these things. That is an behind the doors they can do many things.
That
I'm
is
not
the-
concerned because he's your agent. But moment it is in public domain, it is an award.
No, my lord, this is the letter 17.
What do you want? We have to dismiss it now.
My lord,
No case.
only just a few minutes, my lord, only few minutes, only my lord, the submission that I want to make, my lord. The letter what the 17.4 is in my lord interdepartmental, my lord, correspondence.
But it is in public domain, so it
It
assumes the
is not
status.
public domain, my lord, no notices have been issued to anybody,
Not
nor even to the
necessary.
petitioner.
Is it required for issuance of notice?
My
Show me. Show me as per the National Highways Act. Notice is to be issued.
No, no, my lord, so far as this is, my lord, it is an interdepartmental, my lord,
Where is
communication.
that 17.4?
My lord, at page 73.
73.
73.
Oh.
Page 74, my lord, the copies marked with the official document.
Here also you'll also will find in this page 73. Everything is done as per the, my lord, that particular manual.
Evaluation of the corporate.
It is a draft estimate.
So this is a valid award. We are not wrong.
My lord. So, my lord, this, my lord, letter speaks, my lord, that everything has been done under that particular guidelines, whatever, my lord. Even the
It
issuance
is
of the notice, my lord.
Mr. Counsel, if it is wrong, you have a right under 3G5 which you have already exercised.
No, for that, my lord, there has to be an order, my lord.
Huh?
There has to be an order, my lord.
This is the order.
This is not an order, my lord. It doesn't have the satisfy the element of an order, my lord.
What?
The order has to be, my lord, there's some command or some direction has to be there, my lord. It is not an order, my lord. It is a seeking approval, a letter, my lord.
Page 74, paragraph 3. my lord.
Huh?
Page 74, paragraph 3 of this letter. my lord.
Hereby requested that the amount payable to the beneficiary interested under 3G as per the estimate and close be approved by the central government and the fund amounting rupees so and so be submitted to the joint account of Kala and NHS. The details of the Kala is mentioned in PHA.
This letter has been addressed to general.
So as per you, how the order should be?
My lord, that I have given, my lord, so far as part one, they have passed, my lord, at page 8 of the additional affidavit.
No, whatever they may do, it's a different thing. I'm asking you, as per your guidelines, how the order is required to be passed.
Lordship, my
We
lord.
are not going to decide this aspect on the basis of what the officials do.
Exactly, my lord.
Because if you see in most of the cases of land acquisition in Guwahati and Assam, there is no mention of any order, how it is being done. They only put the estimate, how it is.
Okay. But here.
You may have a quarrel out there that now if you see the annexure to the enclosure to the said document, and you see these are not to be, we need a magnifying glass to be looked into. Final amount to be paid by the beneficiaries, column 15 and 16. This is the award. This is the order.
This is revised 3G estimate for acquisition.
No, this is not. This is what it is. This is the order. 17.4. We are only concerned with these six, na?
My lord.
Mhm.
My lord will find, my lord, the nature of the order are normally passed, my lord, are along with that additional affidavit I have filed, that has been passed in respect of the part one.
No, we are concerned with these six. This is done.
6. my lord.
No case. No review. Review does not, we are not in a
We
review.
call an
We are
order,
not in a
my lord.
appeal, we are on a review jurisdiction. We held that this is an award, again go to Supreme Court.
We've been there, then we have been directed to approach this court.
Where is 18.8?
Yes,
It's 101, my lord.
101. This
And
is,
as per you, this is the award.
this is also a draft. Matlab, this is an approval, seeking approval.
We're speaking.
Matlab,
If they approve it.
This was pursuant to the 17, we have submitted objections. Then thereafter, this letter was forwarded. We having been approved. Now the order is to be passed.
But,
under
may-
3Z. We have
but
deposited
Mr.
the-
Speaker, tell me one thing.
What?
The learned single judge passed an order holding that this 18.8 is not, cannot be issued. You did not challenge that. It was these writ appellants who were before the court.
No, we approached the
Who filed the writ appeal?
NHLDC. NHLDC.
NHLDCL passed the file. Okay.
Our contention was that the 17.7, it is being revised. And as per the revision, we have already paid and the amount has been disbursed. And in fact, my lord, all the amount have been received by them under 18. This fact was also not.
Under?
For this. The amount as per the 18.8 letter, whatever was the assessment, we have deposited. And those are also disbursed to them. This very fact was not mentioned in the writ petition. So therefore, while considering in the writ appeal, the single judge has said the amount as covered by the letter dated 17.4 should be deposited. In fact, we have the 18.8 to be deposited, not 17.4. Single judge said the amount covered by 18.8 to be deposited.
Let's see that.
The judgment of the trial of the Honorable Single Judge is at page 113.
Finally, come to page 124.
Yes, sir.
Finally, the contention of the learned counsel for the respondents that the petitioners ought to have availed statutory remedy under 3G5. Upon being duly considered, this court finds that a revised estimate made by Kala on 18.8 being without any application made by either of parties on the the petitioner cannot be debarred from approaching her. In the result, I find merit in the end is entitled to receive compensation as per the award dated 17.4
Yes.
prepared by Kala. It is further provided here that since there is no period of limitation prescribed parties are here, if any of the application is filed by the respondent, it will be obligated here to deposit the entire amount as awarded as per so and so within a period of a year from the date of the application under so and so before the year. The respondent servers shall then disperse the amount as per the entitlement immediately, and the same shall be without prejudice to their rights to claim for enhanced compensation as per the original award dated so and so.
Right. So we are directed to deposit the amount
As per 18.8.
18.8. And we have already in 2021 itself, we have deposited, that has been
And
disbursed.
they were given the liberty to move 3G. Five.
To file before the arbitrator, etc. Now this,
Then why did you file an appeal?
but we had on the basis of that 17.1, 17.4 is not an award order, it was revised by 18.8. So therefore, they are entitled to only the amount covered by 18.8. Now, in the writ appellate court, Lordship has taking into note that no amount has been received for a long time, though acquisition was done way back. So therefore, to the extent of the amount, has modified the judgment of the Honorable Single Judge by saying that we have to deposit the amount as per the letter dated 17.4.
And you saw the reference on the 3G5 when, after December,
After the direction from the Honorable Court, in the writ appellate judgment.
read appellate judgment you have approached.
Matlab, so far as this, matlab, this particular, matlab, though direction, matlab, in this, matlab, the amount estimated under 18 to be deposited within a period of one month or so, matlab. But this, because of the suppression of the fact that amount has already been received by them.
No, it's okay.
Lordship, matlab.
No. The moment it is received,
Lordship.
now earlier it was 57 crores, now it is 25 as per 18. It's 25. So then you were directed to deposit the 57 by us.
Lordship.
And accordingly, you have filed the 3G5 saying that it should be as per 18.8. 18.8 is the right one, 3G5, 17.4 is not the proper one. Now, the Act of 1956 is silent. Is not only silent, only provides that the competent authority can pass only one order. And the order has been mentioned out there, which is already there, 17.4, wherein that amount has been mentioned out there. This is the amount. So 17.4 is there. Subsequent, any change has to be made. If it is the competent authority is allowed to change, then it is a review. Now the second is, if the award has not been made, if there is no order, if you are saying the entire acquisition goes, you want to return the land, return the land to them, take back the money, and go for a fresh acquisition.
Road itself is matlab, for public interest, matlab, return.
There's no public
only-
interest.
Well, only
There's
the,
no
matlab,
public
the
interest. When you
public-
have not passed an order, and if you say, we are to assume that there is no order passed under 3G1, and you have taken the land, it is in violation of 300A. You have to go for a fresh acquisition. As per date, applying the same principles as per section 26 to 30, and see the value of the land which goes up now.
No, the only thing is that, matlab, the single judge has, matlab, said, matlab, 18/8/2021. Then, matlab, either we or, matlab, the other side can also go to the, matlab, amount will be enhanced only. So far as 17.4 is concerned, that amount is higher, 18/8 is lesser.
No, therefore, both parties, unlike proceedings, unlike the Land Acquisition Act, here any of the parties has been mentioned in
Right,
3G5,
right.
meaning thereby any of the parties can seek reference of it. And then you can very well ask for stay.
But here, because of the specific directions, matlab, this court, matlab,
Deposit, you want to deposit, you have to deposit, but don't disburse. We may clarify that. That it shall be within the jurisdiction of the arbitrator to pass, or even the principal civil court.
arbitrators.
No, you can move under 11 also,
Okay.
arbitrator, because if the arbitrator has not been appointed. Because normally what has happened out here, the central government has issued a circular in the case out here in Assam.
Appointed, but arbitrator appointed.
Arbitrator appointed, then you can move under section 17 seeking for interim and which will be at liberty. We can only extend that. That not as regards not to disburse, taking into account that they are contention, we give you the liberty to approach the arbitrator for seeking interim, and the arbitrator will consider it in accordance with law.
That one.
Arbitrator is
And
also
not-
your person.
The other aspect, my lord, because our contention, my lord, that it's protect to some extent the, my lord, public exchequer, my lord. If the arbitrator retains it,
Therefore, the
amount will
amount
be
will
the
lie.
kala, my lord.
Therefore, Mr. Saikia,
Lord,
the amount will lie with that particular authority.
authority.
You see, the only thing is I can only touch out here we can only touch out here as regards the modification a bit.
Right.
To the effect that that the order passed by us shall not preclude you from moving the arbitrator seeking interim. That we can give you. That is a clarification, but not to review.
Right.
Yeah,
And-
right. Anand.
Lordship. But the other aspect, if your lordship also, my lord, because we are contending that all along we are contending, my lord, that 17 is not an award because it has been modified by the subsequent one, my lord. The letter, it is in draft stage, it is not an order, my lord. So-
That means if 17 is not an award, there is no award at all today. That means it is an illegal appropriation by you. Are you understanding the fallout out there?
Right.
Meaning thereby you have to go for a fresh one. fresh acquisition, fresh assessment. There is no award being, you have taken over the possession illegally. It's an illegal possession by you if there is no order till now. You may have issued a 3D, but for all this period, from the date of the possession, you have to pay the interest.
Well, what I'm contending, the amount which has been assessed, which we objected to with regard to these minerals and the passes have been issued after the 3D notification. That could not have been because it is already vested with, so, well, this aspect also, if arbitrator can look into.
Mr. Saikia, we are not concerned on merits on that.
No,
aspect.
at least a liberty to the arbitrator to at least venture on that matter, whether this amount is entitled.
You have already taken it up. You have categorically mentioned in your application under 3G5, which I could read
Right.
it. You have taken that very issue also.
Lordship, madam.
So therefore, all these issues which are there remain, but 17.4 is the award.
Lordship. Yes, sir.
17.4 is the order under 3G1. Thereupon 18.8 does not arise, but 17.4, but however, you are at liberty to file application and we observe that taking into account the public exchequer, they may consider that.
Yeah.
That is the only way of, only to that
Because,
it's a clarification without touching on the merits.
But the limited matter is that this court having held that this 17 is an award,
Yes, that is an award.
that is an award. So therefore, and direction is also been issued to pay the amount.
So
pertinent to
that is the clarification we are giving.
But-
You have to pay to the collector.
collector, madam. Or the
Now the
arbitrator,
competent
whoever.
authority will have it.
Right.
But the arbitrator can very well give a state not to disperse. That
Right.
clarification we are going to. You are only concerned as regards protection that if the money goes, you will not get back.
Exactly, madam.
So that is will be taken care of by the arbitrator. We'll give the liberty to the arbitrator to do
Right.
that. That's it.
Yes, madam, that is the whole, because here the process, although madam, what is happening, though no order are not passed, interim payments are also made, madam. Moment the notification 3A issued, interim payments are made, parties have been paid interim, and then this amount 20.
All payments which have been made will, you are, Mr. Sir,
strictly-
everybody
strictly-
knows when you have deposited the final amount after 18.8,
No.
well, you have duly taken into consideration what earlier payment you have made.
Okay.
So
Yes, yes,
therefore,
yes.
all
No,
will
no,
be
what-
accounted
no,
for.
on
We
what,
are not
madam,
concerned that way.
on what I am trying to highlight, impress upon your lordship, that no doubt, madam, we have to pay only after the 3G order being passed, we have to deposit. But here, in practice, not only here, many places, madam, the payments have been made, even, madam, order being passed. In interim, etc., then rehabilitation also been carried out. madam, simultaneously.
NHIDCL or what you call the other one,
Highway authority.
they have lots of money. They can do whatever they like. We are not concerned. We are only concerned that 17.4 is the order.
Yeah.
As per 3G1. Liberty which is being given to you, where you have to deposit. However, the release shall be subject to observations being made by the arbitrator. On application being filed within 30 days. Okay. Order will pass that. That is the order. We are not interfering. We are not reviewing. Only we say that 74 is the order. You have gone out there. Now you will be given the liberty to file an application and the arbitrator will duly consider that any release being made. I think the arbitrator will realize
That's it, madam. Those, if this clarified, madam, to some extent.
that is the
madam.
order will be.
Oblast.
We'll pass the order during the course of the. Okay. And you give your names, huh? Madam, whoever is representing the government and all.
But at least that information, madam, if order has been passed, madam, if at all order has been passed, in between the order might have.
Or
been
has
passed.
any order been passed thereafter after 18.8? Madam, can you
Your
hear me?
Lordship. Yes, yes, you're audible, Your Lordship.
Has any order been passed after 18.8.2021 by the Kala?
Your Lordship, I do not represent the Kala.
Huh?
I represent only the state.
The state is the Kala.
The Kala is different, Your Lordship.
who has been appointed as a, can you inquire with the ADC who have done it? Because ADC is under you.
Yes, yes, yes.
Has he passed any order
Mm,
after any order under 3G1? Can you
okay,
inquire with that?
all right, all right. I'll do it.
When can we have it then?
Your Lordship, I can just make a call
Huh?
now also. I can make a call now also.
Okay. Anyways, we intend to pass
Okay.
an order without reviewing it,
Mm.
but the amount has to be deposited by them as directed. However, they are given the liberty to approach the, if they have already approached the arbitrator, they can approach the arbitrator by filing an application under section 17, seeking interim measure, and the arbitrator would have the jurisdiction or authority to pass orders for staying the disbursement. This is the order we have passed.
Noted,
Lord,
yes, Your
I
Lordship.
have taken instruction from my legal counsel, my lord, no order has been passed.
So in fact, order question does not arise because 17.4 is the year.
My
Eight, please, your lordship. Lordship, I beg to mention item number 21, lordship. I may allow to withdraw with the liberty to file fresh, lordship.
Item number,
21, lordship.
why?
Because lordship, certain document I have to annex, lordship, in this case, lordship. Certain development has taken place, lordship. I have to annex certain
What
documents.
development?
Because lordship, that time,
Where's
lordship,
the
my
other
prayer,
side?
lordship, my prayer was that for depositing that fees from 20 to from 15 to 20, lordship. Now I'm ready to pay up to 25, lordship. That much, lordship. You have to amount this way.
What was the case for?
Lordship, this is the land was lordship actually leased abandoned land of the railway lordship. It was given to my grandfather lordship. Thereafter, this license was transferred to me lordship. Thereafter, lordship, I'm ready to pay that license fee lordship, but they are not accepting that one lordship.
Obviously. So,
May I lordship allow it liberty?
no
to file?
liberty. Withdraw.
Would you allow me?
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant petition, taking into account above the instant petition such to withdraw.
Hello.
Last Friday, I made a mention for this thing and putting a parent to here, it is not listed. It's 2 years.
Why?
It's not listed, there's an urgency there. Here.
What is the matter?
The illegal construction is going on in the sub-center of medical health center. Outside is registered. Construction of medical sub-center.
Motion.
Motion, yeah.
It has not been listed.
Not listed to that.
Must be some defect. After giving you the permission, why it wouldn't have been listed?
I have take out the defect. There is
Chalo, not today, tomorrow, Wednesday.
tomorrow.
Wednesday. No heavens is going to fall.
May I please, your worship? I beg for mention for adjournment item number 27.
Why?
My lordship, my senior is suffering, his stomach is upset. He cannot be appeared. His stomach is upset.
Not be?
He cannot be appeared. His stomach is upset. He's suffering from
I don't get you.
abdominal pain.
The council. And it 27 has come by order. Who has brought it by order? You're mentioning about 27.
Yes, lordship.
Then, on one hand, you bring it by order and then you don't want to do it.
Your lordship, I beg for can we be listed for day after tomorrow, your lordship?
No. This will go Sunday. Is there an interim order?
No,
Interim order?
no, sir.
No. Stop. The council appearing on behalf of the petitioner seeks for an accommodation. Stop. It is relevant to observe that the instant petition has been brought in, has been listed today at the request made by the petitioner. Stop. Under such circumstances, as the petitioner is not inclined to do the matter, list the matter after 6 weeks. Yes.
May I please your lordships? I'm appearing on behalf of R.D. Bora.
With due consent from the others that I beg to mention item number 41 and 42.
31 and 40.
41 and 42.
41 and
42. 42. In these two matters, Lordship Authority is going to pass a speaking order. To complete the instruction unit 1 with time.
Why you are asking for mentioning? These are contempt of 2022 and you are mentioning nothing with it. No adjournment. Next.
No, I beg to mention, in this case, I am for the petitioner matter, in both the cases. And they are saying that they are going to pass the speaking order
Who?
within the
In
petition.
this case,
Yes, ma'am.
it has been submitted by the learned counsel appearing on behalf of the respondent number 3. That the concerned respondents, the officials are taking steps for passing a speaking order. To accordingly, list this matter again on 20/08/2025, for an update.
In
41 and 42, na?
item number 14, my lord, 14. 14. This is some typographical error in the post title number. So I may be allowed to withdraw this petition with file in liberty.
What typographical error?
My lord, typographical error in the post title, my lord, in the page number 3, in the petition.
Don't worry, we'll ask you to file a fresh cause title. Cause title, we are not concerned. We are concerned with the pleadings.
With the consent of other side, Lordship, I beg to mention item number 54. Here, Lordship, every morning only copies, extra copies are served to. 54.
Today morning,
Because of Lordship.
Mr.
initially-
S.S. Roy, the learned CGSC, submits that today in the morning hours, the extra copies of the writ petition has been served. And as such, he has not been able to obtain any instructions. Is there a state
No,
taking into account the above, list the matter of the 6 weeks?
my lord, if any date may be fixed.
Absolutely no. You, in the matter of 2024, you serve extra copies today, and now you want this? No premium.
Much obliged.
But plead your lordship, I beg to mention item number 23 for adjournment, your lordship.
23? Why?
Your lordship, the counsel for the petitioners are appearing before the Itanagar bench today, your lordship. They're not
Huh?
available. Your lordship, the counsel for the petitioners are not available, your lordship.
So,
They're appearing before the Itanagar bench today.
টিভি তো চলা নাই নেকি? নাই কৰা। I don't grant adjournment on senior counsels. Where is Mr. Kyle?
Your lordship, he is appearing before the Itanagar bench today, your lordship.
Where is Mr. Kane Chaudhary?
Your lordship, he is also appearing before the Itanagar bench. your lordship.
None appears for the petitioner on call. The list the matter for 4 weeks.
Supplementary item 63.
They are online, my lord.
Yes, Mr. B. Gogoi, why you are not complying?
Well, so far as there is a slight misunderstanding of the order. They came to me, I explained to them, they are praying, within 4 weeks, they will make the payment of 20 lakhs.
Huh?
Within 4 weeks, they will make the payment of that 20 lakhs. Actually, this is a forest royalty issue. They want that it should be deducted, but that judgment of Muslim law is very clear. You'll have to, they will have to be a specific clause. They have mentioned about one clause. that is
Why
for-
then, on that day, I would have granted you the opportunity, but the instruction, first of all, you have to understand,
My lord.
Justice Goswami's order makes it very clear that if you don't file your affidavit in opposition, then in that regard, there has to be a personal appearance. So that order I had to be followed, one. Secondly, the instruction which had been placed before this court is that the officials wants to file an appeal.
Lordship.
And as such, they are not inclined to comply with the directions. I have no other option.
No, I understand, my lord. That shouldn't have been placed, my lord. Otherwise now, my lord, I've explained to them. Now, my lord, that 40.
Yes, who is appearing? I've asked the 4 respondents to appear.
Well, it is the main commissioner and the civil engineer who is supposed to, my lord, comply. They are present.
Who is the commissioner?
Commissioner.
Mr. Chandan. I can't hear you. I think there's something problem. I can't hear you.
Secretary, Public Works Road Department.
Now, why you are not making the payment in spite of the clear categorical directions being passed by the Scott?
Your Lordship, first of all, I offer my sincere apologies to the Honorable Guwahati High Court for the delay occurred in complying with the Honorable Court's order, WPC, that is 5305/2022 and contempt case 579/2024 due to some interpretation issues of the contractual conditions. In that case, the executive engineer has deducted a royalty amount of about 22,95,238 rupees as per interpretation of the contractual conditions. And the amount was deposited to the state exchequer by Judicial Challans. Now the department has decided to refund the money deducted as forest royalty to the contractor in compliance with the Honorable Court's order, and thereafter will take up the matter with the forest department for reimbursement of the sum that is deducted from the petitioner. Now
And
the
what
Petroleum
about the
Department
2
has
lakh amount?
taken. Pardon,
Sharma, what about the 2 lakh amount? You see, there was a observation being made. There are 2 aspects. One, there was a direction to pay the amount of rupees, reimburse the amount of rupees 22,50,799 within a period of 15 days. And the second is, there was an illegal deduction which had been made of an amount of rupees 2 lakhs. And this was directed to be verified within a period of 3 months and thereupon to return. If it is found, have you made any verifications to that effect?
Yes, Lordship, we are doing the verification and we will refund that amount also after verification.
So you'll be doing so within a period of 4 weeks from today.
4 to 6 weeks, at least 4 to 6 weeks time will require, Your
Huh?
Lordship. 4 to 6 weeks time we may require.
4 weeks. We fix a date.
Okay,
And we
okay.
fix the matter again after 4 weeks, a date. We want that the only update be given that the amount has been paid to the petitioner. Okay.
Yes, Your Lordship.
Who is present today? Mr. Gustav.
It's the commissioner and the civil engineer.
Lordship, one thing, Lordship. The 2 lakh is concerned. We have returned that 2 lakh.
You have got the 2 lakh.
Got it.
Okay, you have got that.
So 2 lakhs what?
Yes,
My lord, after 4 weeks, a date will be given.
4 weeks. Good. So pursuant to the order passed by this court on 23/7/2025, the respondent number 1 and 2 are present through the video conferencing link provided by Mr. A. Solia, the learned counsel appearing on behalf of the said respondents. Gustav, it has been submitted before this court. The respondent number 1 and 2 have given an undertaking before this court that the amount of rupees 22,50,799 would be disbursed to the petitioner within a period of 4 weeks from today. Gustav, it has been also brought to the attention of this court that the amount of rupees 2 lakhs, which was illegally deducted and directed to be verified and paid to the petitioner, have already been paid. Gustav, taking into account the above, list this matter on 26th of August 2025, 27th of August 2025 at 10:30 a.m. for an update as to whether the amount of rupees 22,50,799 have been duly paid to the petitioner as per the undertaking so submitted by the respondent numbers 1 and 2 today. The personal appearance of the respondents are dispensed with. List accordingly.
Motion item 1 to 13.
Made, please, Lordship.
Yes.
In Lordship, in 5 matters, my lord, at serial number 2, 3, 4, 5, and 7, my lord, we have filed the additional affidavit. For remaining matters, my lord, I was praying some more time, my lord, because we have applied on 31st May itself. And only in 5 matters we have received the additional documents, my lord, which we have filed. But for remaining matters, I was praying some more time may be given, my lord, for filing additional document.
Yes, Mr. Rochaudhary. We are paying for all.
My lord, I appeal for all, but you have not received any copy of additional affidavit.
My goodness, what is wrong?
My lord,
Why you have not given a copy?
my lord, it will be served during the course of the day.
Huh?
It will be served during the course of the day, my lord. My
Yeah,
learned,
cost of 10,000 for matter.
my lord, my learned. friend
7
could not
matters,
come from
how
Shillong.
many matters are there? 13 matters. 1,30,000 you get it. 10,000 rupees cost.
My lord, my instructing counsel couldn't.
Okay, we impose personal cost upon you.
My lord,
1,30,000.
my lord, we could only file it on Friday.
So what?
And we have,
How on earth can you file without giving extra advance copy to the other side?
my lord, we have given the advance copy to the state,
No.
to the
Why state?
and to the private respondent, my lord, we'll serve it today itself in the course of.
Why you have not? How did you file it at all? Therefore, it is not come on record. It has not come on record. That is the
My
reason
lord,
why.
we have the filing slips with us.
We are not concerned. You can file anywhere. You can throw it in the dustbin also. They can maybe throw it. We have a rules out here which says that there is an extra copy. A advance copy has to be given to the respondent.
My lord, I'll just.
Why haven't you given?
My lord, we were under
And
the,
you are asking for an adjournment.
we were under the impression, my lord. we will do
10,000
it- we'll do
cost.
it in the course of the day.
You have got. Our Grid Corporation has good money. 10,000 each. So it's 1,30,000.
My lord, may kindly consider this.
Huh? 5,000.
My lord, may kindly consider this time, my lord.
No, no.
Because his base is
Let-
Shillong, my lord. That is why the
65,000.
his base is Shillong. That is why he could
What?
not come personally and.
I have asked you to do it on
I
13,
understand.
60,000.
I fully appreciate it.
I will give you time till October. But I will direct that the district judge should go ahead with the execution. This court, by an order dated, this court have been taking up this batch of proceeding, batch of applications. Since 2025. And have granted various opportunities to the petitioner to file additional pleadings as well as to bring on record the order sheets so passed before the learned court of the district judge. Full stop. It has been brought to the attention of this court that in respect to 5 of the applications, certain additional pleadings have been filed. However, the same have been filed without providing advance copy to the respondents, private respondents. The practice followed as per the Guwahati High Court rules that whenever any pleadings are being filed, advance copy is required to be furnished. Mr. So-and-so, the learned counsel assisting Mr. R. Sharma, the learned senior counsel appearing on behalf of the petitioner, submits that during the course of the day, the said copies would be furnished to the learned counsel appearing on behalf of the private respondents. The learned counsel, senior counsel appearing on behalf of the petitioner further seeks for some time that in respect to the remaining 8 matters, the additional pleadings should be filed. Taking into account the above, let's list this matter again on 22nd of September 2025. In the meantime, as there is no stay to the proceedings, in the meantime, as no notice have yet been issued in the instant proceedings, and there being no stay, the respondent, the learned court of the district judge would be at liberty to proceed for realization of the said amount as directed in the various matters.
Item 14.
Yes, what is this?
But here, I apply portrait petrol from for the category 1.
Huh?
I apply.
It is always
Can
the
it-
case, whenever retail outlets are being given, that they apply in category 1. And then they are reverted back to category 3. And this must have happened to you also.
But this is not my case, my lord. In case here.
And you say that the document which you have given is the proper document.
And the private respondent who is there. The private respondent has submitted some documents that he has some grievances. But what are the documents he has filed that was not reflected in the expedition?
Whether he is qualified.
No.
I am qualified. Petitioner is the qualified. My case is that, my lord. First draw of lots was conducted on 8/12/2023. On that day, the respondent number 4 was declared as winner. Later,
Yes.
respondent number 4 declared as winner.
In the lottery.
Yes, madam.
Ah.
A second, day after they have conducted the redraw by cancelling the earlier draw of lots 8/12/2023. But they have declared that he is not eligible person, that respondent number.
As per category 1.
Yes, my lord. Later on, they have conducted again redraw on 22/2/2024, whereby the respondent number 2 has been declared as winner of the lottery. Respondent number 2.
Respondent number 2.
Yes, my lord.
Ah.
4 is gone.
The first, it was respondent number 4.
4.
Then
Later
respondent
on,
number 2.
2 is declared as winner. Thereafter, my lord, I get some information that the respondent number 3 and 5, they are not own any land for this particular area, my lord. Neither they have possessed any lease from the owner of the land, because I am the co-partner of that particular location. Then. So they didn't apply for the NOC or for the lease. So my prayer is here, my lord.
So the land which is being offered by respondent number 2 does not meet with the criteria for category 1.
No, I'm not on that, madam. 3 and 5. Respondent number 3 and 5. Respondent number 2, I don't know. Mike, they have.
Who is the winner?
2.
Then why you are not concerned with 2? Why we are concerned with 3 and 5?
Because this is the irregular lottery, madam. They are not following the procedure, madam. Because what they have said that page number 45.
No application. Don't them file any documents, madam.
Huh?
At the time of filing the application online, there is no need to file any documents, madam. It is only after.
Yes, after
processing
that
in the
it is
draw
being
lot,
asked.
it is being verified, it will be verified.
Can you see
So
one?
3 and 5 were not selected.
So here
Who has
he
been
is not, he is now 2 has been
Who is
selected. 2 having been selected, and he has no quarrel with 2.
Yes.
He has quarrel with 3 and 5. Then what is that? He's the winner.
My question
Your chance of lottery would have been better, isn't it?
my lord. If they have redraw the lottery, then I might be, it's a lottery, my lord.
Yeah, then if it is done amongst 2, it would have been better.
2 and me, yes, my lord.
Yeah.
My lord, can you see the page number 45, my lord? Page number 45.
Yes.
The paragraph 14, rule 14,
Ah.
a draw of lots. Selection through the draw of lots amongst eligible candidates will be made for the.
Yet I understand.
So that.
So if
respondent
it
number
is
3 and 5
between
are not
2
eligible.
person, your chance is much more.
Much more, yeah.
Ah.
Because they are not eligible person 3 and 5. That is the only.
No, but 2 is eligible.
Who is eligible?
Then
It might be different, my lord.
What do you
2 and
want?
5
I can do one thing. The case for dismissal. Right?
Madam, may issue notice. Madam.
What?
Let them. Notice may be issued, then let them.
Didn't you see in the earlier matter? I've given 6 times accommodation to the petitioners, but I have not issued notice till now. Getting a notice here is in itself, you will be winning the case. I don't issue a notice, but here you no notice, you dismiss it.
He is to withdraw and get a calm with it better.
Huh?
He is to withdraw this case and come with a better documents.
Better documents.
Challenging the
Respondent.
Response number 2, how can you challenge if his documents are okay?
Yeah.
Then,
Only
no.
that- only
What do you want? Dismissal, withdrawal, which one?
I will withdraw with liberty. my lord.
What liberty? No liberty
If I-
business.
If I can gather the any documents that the respondent number 2, that they have. Then
The learned counsel appearing on behalf, heard Mr. A. Boro, the learned counsel appearing on behalf of the petitioner, and Mr. S. Bothakur, the learned counsel appearing on behalf of the Bharat Petroleum Corporation Limited. So, the petitioner herein have challenged you are eligible as per class 1, na?
Class 1, yes.
Category. The petitioner herein who had applied in respect to in pursuance to advertisement issued on 28/6/2023 had applied for allotment of a retail outlet at Thalpukuri between Thalpukuri, Dasgaon, Shiv Mandir, Piniali and Shikari Gate Bazaar, bracket, not on NH/SH. The case of the petitioner herein that the respondent number 3 and 5 could not have applied in terms with category 1, in terms with category 1. And as such, taking into consideration taking into consideration that they were included within the draw of lots pertaining to category 1, the chance of the petitioner to be selected have been affected. Mr. S. Bothakur submits that in the draw of lots, the respondent number 2 have been selected, have been declared to be the winner. And if the respondent number 2 is not in a position to provide necessary documents, there will be a fresh draw of lots. This court have given in consideration to the submission and taking into account that the respondent number 2 has been declared to be the winner in the draw of lots, and there been no allegation that the respondent number 2 does not qualify to apply in terms with class in the category 1, in the opinion of this court, the instant petition is misconceived. It is, however, observed accordingly, this court dismisses the instant petition. It is, however, observed that in the circumstance the respondent number 2 do not satisfy its candidature as a category 1 candidate, it shall not be a bar on the part of the petitioner to again approach this court.
Item 15.
Where will you go?
What is this?
In this case, I applied for a license, my lord, arms license, my lord.
What
And
license?
District go, as of today, the district magistrate has failed to dispose of the document.
What license is this?
Arms license, my lord.
Arms license. Why do you want that?
Because I'm a contractor, my lord, I have to give labor payment. There's the problems are there, my lord, I'm facing, my lord.
Take a PSO. Why do you need an arms license?
But the OC has recommended it, my lord. But there was a.
Madam, you have a committee also, no? Okay, we'll issue a notice.
Yeah.
Issue notice making it returnable on 22nd of October 2025. Steps, Miss S. Yudas, the learned additional senior government advocate, appears and accepts notice on behalf of all the respondents. Extra copies of the writ petition be furnished to the learned council. Be furnished by 31st of July 2025. The case of the petitioner herein is that the petitioner has a threat to his life and as such had filed an application seeking an arms license.
There is Annexure 3, my lord. 512. Annexure 3, my lord. Case 3. So the district magistrate.
On 5/12/2022.
Yeah.
In spite of, on various occasions, the petitioners represented to the respondent authorities to consider the said application. However, the same have not been done, for which the petitioner is before this court.
Verification done and kind of not recommended.
Is it so? Where?
Verification was done, but district magistrate did not pass any order.
Huh?
If the licensing authority is the district magistrate.
No, full stop. It is the case of the petitioner that that pursuant to submission of the said application seeking fresh arms license, comma, on 1/6/2023, a report was submitted to the to the district magistrate by the Deputy Commissioner of Police Intelligence, stating entirely that the issuance of arms license to the petitioner was not recommended.
But there are two recommendations. One recommendation, OC has recommended, my lord, but the deputy commissioner did not recommend.
And you have not challenged that. Oh, you have challenged it.
Yeah.
So the petitioner have challenged the said communication dated 1/6/2023 by way of the present proceedings. And further sought for direction that the respondent's authority be directed for issuance of the arms license. The respondents herein are directed to bring on record their stand by filing the affidavit.
Because the ultimate authority is the district magistrate. Ultimate licensing authority is the district magistrate.
So you are asking that when the deputy commissioner says that you should not, you are insisting on the officer in charge.
But no reasons have been given, my lord.
Reasons are very difficult. This is a question of arms license.
But faith, conception, perception is there.
Supplementary item 16.
Get it sometime in 2035. Right. Yes, what is this?
My lord, we have challenged the local Adalat order.
That I have passed, I know that.
Yes, my lord, I have helped today. Note that letter was served upon the bar council by post.
Notice making it returnable on why you are making the Assam State Consumer Dispute Redressal?
Matlab, the local settlement was done in that manner. And matlab, we filed a miscellaneous application also before the.
Huh?
We also filed a miscellaneous application before the consumer forum, matlab, that consumer forum. There, matlab, it was rejected.
So
matlab, as the settlement was done before the state consumer redressal formal, that's why.
now, are you not challenging the order passed in the local order?
Yes, matlab.
Then you filed an application before that for recalling. Huh?
For the local adalat, we have not filed. Now we have filed.
Then why are you making that for district consumer forum a party? Why?
It was, we filed the application matlab, before the state consumer forum. Matlab. We filed an application after the local adalat settlement. Matlab. Page number 30 and 31 matlab, order over there.
You filed an appeal. Who filed an appeal?
We matlab.
In the appellate,
Yes, matlab.
challenging the order of 3,32,000.
Yes, matlab.
And the local adalat amount came to 4,57,000.
Yes, matlab.
I don't think we need to issue notice to respond number 2.
Right.
Issue notice. This local adalat order is passed under what provision?
Section 21, matlab. Section 21.
Of,
The legal services, the Legal Services Authorities Act.
and if it is the order is it a decree?
Yes, matlab, if any settlement order is made, matlab, they can go for execution.
So it's a decree. If it's a decree, can I exercise my right powers on the 226 or 227?
Yes, matlab. If matlab, signature of parties are missing, matlab, then only, matlab.
I don't understand.
Yes.
But can I exercise the powers on the 226
Yes,
or
ma'am.
227?
Your logic can.
Which one?
Matlab, I have a citation on that, matlab. Paragraph number 12 is
Paragraph number?
12.
Notice dated returnable on 22nd of September 2025. Issue notice upon the respond number 1. So this court is not inclined to the said steps. This court is not inclined to issue notice upon the respond number 2. So, steps be taken as regards to respond number 1 by way of registered as well as usual. The case of the petitioner herein is that the respondent number 1 had filed an application before the District Consumer Redressal Forum, Walpura, seeking compensation on account of his vehicle which he had taken on hire purchase.
Yes.
Was repossessed by the petitioner's hearing. The said complaint petition was registered and numbered as CP number 02/2017. The District Consumer Dispute Redressal Forum, by an order dated 5/1/2018, directed the petitioner to pay an amount of 3,32,949 against the said ex parte order dated 5/1/2018. The petitioner filed an appeal before the State Consumer Disputes Redressal Commission, which was registered and numbered as FA number 76/2018. In the same proceedings pending before the State Consumer Dispute Redressal Commission was forwarded to the National Lok Adalat. And this aspect of the matter was not, and it has been alleged that this aspect of the matter was not informed to the petitioner by the counsel who represented the petitioner before the State Consumer Disputes Redressal Commission. And it has been further alleged that in absence of any instruction, the counsel accepted an award of rupees 4,57,949 against the petitioner, which was completely unauthorized, and as such have challenged the said award dated 14/9/2024, passed by the National Lok Adalat by the present proceedings. Mr. U.K. Burman, the learned counsel, appearing on behalf of the petitioner, submits that the counsel who represented the petitioner had no instructions from the petitioner to enter into any sort of agreement on behalf of the petitioner. He further submitted that the conduct of the counsel was unbecoming of an advocate, and for which an application, a complaint have also been lodged before the Bar Council of Assam, Nagaland, Mizoram, and Arunachal Pradesh and Sikkim. The learned counsel further submitted that in the instant case, when the petitioners have assailed the ex parte award dated the ex parte order dated 5/1/2018, directing the petitioner to pay an amount of rupees 3,32,949, the question does not arise for the petitioner to accept an amount which is much higher, that is rupees 4,57,949. He therefore submitted that this is a case where a fraud had been played upon the petitioner by the respondent number one, hearing in concert and in collusion with the counsel appearing on behalf, who appeared on behalf of the petitioner in the said proceedings. So taking into account the said submissions, it is the opinion of this court that the petitioner had been able to make out a fit case for stay. Are you asking for stay?
Yes.
Stay of the impugned award dated 14/9/2024, passed in FA number 76 of the 2018, the next date. Accordingly, it's the so and so and stay in the next.
Their money execution case number is 1 of 2025.
State, it has been all verified. Required to be state. As well as the execution proceedings so initiated thereof. Accordingly, so and so, as well as money execution case number
1 of 2025.
1 of pending before the court of the so and so shall remain state in the next.
Replayable.
Lagi. Item 62.
Maybe your lordship. Last occasion, 23rd, the direction was given. On the last occasion, lordship may place the facts. Lordship,
Yes, what is this?
Group 1 and Group 3, lordship. Now, what had happened is the lordship I had applied. I had given my land and they had rejected my land and they have reverted me back to Group 3. Lordship may peruse page 52 of the impugned communication.
I am concerned with page 62G. Did you submit this consent letter? Isn't this the case, Mr. Guru?
But lordship, I later on there is a document, lordship.
Later on is later on. I'm not on that. Did you submit this document? Did they give you the opportunity and did you submit the document? Because this is being first done, first they will be going as per the draw of laws. After the draw of laws, they will be directed to produce the documents.
Gotcha.
When they submit the documents, if it is a joint land, or it's a land belonging to everybody, there is no partition, then they have to give the consent.
But yes, there is signed in case of a lease deed, all the co-owners have to sign the lease. Co-owners.
No. What do you say about
45, lordship, 45.
42, 62, page 62.
Yes, lordship G, page 45 is my affidavit.
62G.
Land owned by the family members will also be considered as belonging to the applicants subject to producing the consent letter in the form of. No, my lord, this is when the applicant is a family member. In this case, the applicant is a Chakia Rabha. He has leased the land from a family unit. This is when the applicant is itself part of that family unit. The applicant has land which is owned by other members of his family. That is the event when the consent letter is required. I have a land I'm offering which is owned by my brothers and siblings as well. Then I need this consent letter. In this case, the applicant is a stranger who has leased the land from two brothers who jointly own the land along with the deceased brother. Now, on the date of application, it was on 17th of October 2023. The land had not been partitioned.
Which is the clause for the lease? Lease
Page 63,
61,
61.
the lease, and then group 2 is for a suitable piece of land for purchase or long-term lease for a year. So group 2 is having a firm offer. And here who has a lease already?
With the lease. My lease
Now
deed is,
what happens? The land is also for the dealer. Wait, what does it say about the lease here? The other conditions offering, the land should be available with the applicant as on the date of the application and should have a minimum lease of so and so from the date of our year. The offered land is on now the leases should be have a provision or subject to the Yes. How do you take care of his submission?
Lordship, they have, if they have said that I have my things are not in compliance with 4A, which Lordship have just read. 46A, page 61.
46A.
Which Lordship has just read. Lordship, it says that the first condition is 19 years. My lease deed may be taken for it's 23 years. Second, it says they have confused between co-owners and co-pattadas. Even if there were three pattadas out there. Now these three pattadas, the third pattada has given an affidavit saying that she has no objection if it is leased out. And this regarding, there are 2 bighas of land, 1 bigha has been leased out. That is which the Zakia Rabha has taken from the owner. And moreover, Lordship, we had partitioned it and we had also given the document to them.
No, I saw this because if I remember correctly, the earlier affidavit which have been filed
by the third one
contains Bonali Sutra. These are all the relations.
Yes, relations, Lordship. Bonali,
these are all family. Except Bonali Sutra is the daughter of somebody else.
No, she's the wife of the brother.
Huh?
Who has expired.
So they are family members.
Family members.
So therefore, these family members, these are co-owners.
No, Lordship, now the co-owners will be already, now they are co-owners of what? They are now 1 bigger plot of land is there. That has been leased out to me. Are they co-owners of that 1 bigger? Lordship, because they have been partitioned now.
Where?
Lordship, may we come to page number 50? Page 50.
Where is the partition?
Page 50. These were the, now in this dark number, in patta number 13 and dark number 90, there are only 2 co-pattadas, co-owners, whatever they want to call it.
So Bonali Sutra's name has been struck off.
Struck off.
When?
Now they have been
4/12/2020.
And we have informed them also.
For
December 2024. On the
December
right side.
24. December. And when was your lease deed done?
17/10/2023.
It was 4th of December 2024. This was done.
No, this was done not for 10/4/2025.
4/12/2000 as per the order. Page 50. And the lease deed was
17/10/2023.
16/10/2020. 16/10.
in 10/2023. Okay, that might not be there. But what about this is the land is 1 bigha, 2 katha, 2 lechas.
Yes, Lord.
Okay. This is understandable. But when was the last date of submission?
Lordship, once draw of lots have done, then I submitted the, no, Lordship.
No, you have to have that on, yeah, I will say, when was the last date of submission?
I submitted on,
As on the date of application.
as on the 7/10/23. I submitted on 17/10/23.
17/10/2023. Okay. So then it was there. And when was the draw of lots done?
Draw of lots was done on
27/12/23.
27/12/23.
So as on that date, thereafter you have been asked to produce the documents. Now against that, you did not produce that. This document came later on. When
This-
was your rejection?
My rejection is of, my rejection is of 19 July 2025.
19 July
2025.
25.
25.
So
Sorry,
in the-
sorry, Lordship, 17 July. 17 July.
17 July
2025.
25. Okay. So as on that date, this was a single plot of
Yes. And Lordship, even if, just assuming for a moment, the affidavit given by Bonali Sutradhar, will it have no value? She has clearly stated about it. It's not that she's that affidavit is given where she has said this land is given to the petroleum link. She has no objection.
But did you give that document?
Lordship, that is my affidavit by Bonali Sutradhar. Now,
Did you submit that document before these authorities?
yes, this affidavit was there.
Affidavit, not the affidavit, the verification exercise was conducted on 23/4/2024.
No,
Even as of 23 April 2024, LEC field visit. All the documents were verified. As on date, the land was not partitioned, there was no Joma Bondi, there was no striking of the name. And second part, my lord, more crucial is that this brother who died, he is a wife born Ali Sutradhar. He has 4 children. 3 of them are majors. They are also co-owners. Their ownership was also required. Not
By that time, now the name of them have been struck off prior to your decision-making process. Your decision is of 17/7/2025. As on that day, there is already an order by which this particular plot of land was made exactly which comes within the ambit of this as per the lease. So there is no problem with that then.
Well, because at that time, because in the field verification report as well as surplus report states that there are 2 co-owners other than that of the one. One is
Understood.
Basanta,
There is no quarrel.
one is the pair.
Now, did you submit these documents?
Yes, Lordship, I have given a statement also.
Jamapandi,
I have given a statement also.
These
On 1st June 2025, I have submitted, I have given a statement also.
yes, that is,
That is, I have submitted.
but you,
I have submitted the document.
Because why I'm saying so, if you see this page 62. Where is the appendix 3? Mr. Counsel, I'm not going to grant you any stay. Why you have not enclosed? Where is the appendix 3? No. Sorry. I've given you one opportunity.
Lordship, that's,
In spite of that, we have not given. You have only put the relevant. Means you are not interested.
no, Lordship,
We dismiss it on the ground of not placing them.
not Lordship,
In
that,
spite of an opportunity.
no, Lordship, because
You
Lordship,
go ahead and hand it to.
no, Lordship,
No,
Lordship,
I give
Lordship-
you an opportunity.
no,
Leave the
Lordship,
matter
because
in
here,
on with-
Lordship,
to bring on record the brochure for LRP. when there is a direction to produce the brochure for allotment, do you mean that we'll do only a part of it?
Lordship,
It will really show very poorly upon you.
no, Lordship, that
When your client will know that because of some material instructions, you have not enclosed the entire for which he has got he will be losing his
no, Lordship,
cause of action.
that for my fault, let them, because I'm extremely sorry for this, because Lordship, I mean, this part,
Let the District Legal Service Authority profit because of your lapses, 15,000.
Lordship, I will not be able to 15,000. I'll pay any other amount, Lordship, because this is my fault. I accept the fault.
So the cost is on you only.
I'm going to pay, Lordship. I'm not going to
Make
impose.
it 20 then.
No, Lordship, I will not be able to pay 20, Lordship. Lordship, Lordship, what I submit is that it may come day after tomorrow. Day after tomorrow.
No. You don't seem to be in urgency.
No, Lordship, I am in urgency.
When I gave you this permission to do it, you have not done so. Earlier, I gave you a permission.
Lordship, yes.
When this matter came up, immediately I asked, where's the brochure?
Yes, Lordship.
Then you say that, okay, let me bring the brochure. And therefore, I passed an order on 23/7. And as of now, you have not been able to bring it.
No, Lordship, I have brought the.
You'll have it in the month of.
No, Lordship, I'm extremely.
Puja,
no, Lordship.
After Puja, it will be better.
Lordship, I'm extremely sorry for that thing. I'm ready to. Lordship, let the.
25,000 costs upon you.
Lordship, I won't be able to pay that much. Lordship, if we impose it, then that's it. But I'm extremely sorry because for my fault, let the client not
Have
suffer.
a vehicle, put it on mortgage. Better.
No, Lordship, because I pay, let it come day after tomorrow. I'll put it.
No.
Lordship, what had happened is.
This can't happen.
No, Lordship, I'm extremely sorry for this thing. I'm
It is
extremely.
clean. During the, while hearing the matter, this court, by the specific order dated 23/7/2025, directed the petitioner, granted the liberty to the petitioner to file an additional affidavit, bringing on record the brochure for allotment of the retail outlet by the respondent corporation. It is seen. That an additional affidavit was filed thereupon. But surprisingly, the entire brochure for allotment of the retail outlet by the respondent corporation have not been brought in for reasons best known. This assumes importance taking into account that the requirement of filing those affidavits or consent letters have to be in terms with the appendixes which are attached to the brochure. As the entire this court gave an option to the learned counsel appearing on behalf of the petitioner as to whether the petitioner would like to bring the entire brochure or take the entire brochure or require the decision of this court on the matter without the brochure. Option given. Now,
Lordship.
do you want the entire brochure or the decision of this court? I'll dismiss it. The brochure has not on suppression of material fact. Which one do you want?
Lordship, I have not suppressed any material fact.
No,
Lordship.
you have not brought in.
That, Lordship, I admit my mistake.
What do you want? I gave you the option.
Lordship.
What option do you want?
So, Lordship, I'll bring the brochure day after tomorrow.
Counsel appearing on behalf of the petitioner submits that he will bring on record the entire brochure, which inclusive of the appendix. List this matter again on
day after, Lordship.
11th of August 2025.
Deprecating items 16 and 17.
May it please your lordship. Your lordship, I am appearing through VC. I apologize for not being there physically present, your lordship, due to an unavoidable circumstance. Lordship, I am actually for respondent number 2 to 4, but it is Assam Tourism, and it is an IA that we have filed, because of which the matter has got listed. The IA is listed today, Your Lordship.
Submit for a meeting.
I for what?
It's for vacation.
IA for vacation of stay, Your Lordship. So, sorry.
The inter-party order was passed sometime in the year 2022. They filed a response in the 2022, but 3 years later, they filed a vacating application. They received on the 2nd of July this month. They pay for some accommodation, if allowed. Hence, we have to argue them.
I'm very kind in granting it.
Otherwise, we'll argue them. Not issue. The first date was listed. The first date was listed.
Yeah, they filed a reply also.
Yes, it's definitely.
Let's take up the matter for final disposal now.
We can. Your
Petitioner.
Lordship. Your Lordship, yes, we can. Your Lordship, I'm the respondent for 224.
You
Yes.
don't say anything.
Yes, Your Lordship.
First, let us hear what the petitioner has, and if the petitioner has a good case, we'll allow the petition. Why should we go into the small nitty?
Lordship takes up WPC.
We are taking up the matter for final disposal.
My Lord takes up writ petition 5687 of 202.
5687, okay. What is this?
My Lord,
What are you challenging?
I've
Tender
challenged
process.
my Lordships.
Tender process.
Tender process, my rejection, and
Rejection of your tender.
my tender, technical bids.
And why there are two? The second one must be too
Initially, when they
challenging.
floated a tender, I run a houseboat, and houseboat was not indicated as an eligibility criteria, where they indicated hotels to be
No, no,
one.
why there are two petitions?
Initially, I filed that. Then I was asked by the Honorable Court to approach the authorities. Then they allowed me to participate. In terms of the rules of this Assam government, the houseboat is included in hotels. I participated. Now, after I participated, they rejected my technical bid. The reasons were not given. However, I could gather that there is a requirement that I have to cross 60 marks in a technical qualification, which they say in affidavit, I did not do so, but without spelling out how I did not do so. And they say that the 5th and the 6th respondent have done so. I had brought in specific allegations against respondent number 5 and 6 to the extent, number 1, so far as respondent number 5 is concerned, I said that they have not submitted it online, which they're required to do, and certificates of A, B, C, D, E, whatever is required. It was self-certified, which was not required. You could not submit self-certified documents. So far, respondent number 6, we said the same, and they had not submitted online. In response, in the affidavit, they have stated that so far as respondent number 5 is concerned, respondent number 5 submitted scanned copies of relevant documents, and it would go fine with them. We say there's a clause which requires online submission, and self-certification did not find default in their eyes. A small question which would fall for consideration is that it may come my way, may go against my way, is that when copies certified to be produced before the authorities in the tender process, if self-certified is permitted but not indicated, whether it would be rational for all to understand in the same page.
So you want now the entire tender process should go.
Not quite. If my ground of rejection of technical bid is made open vis-a-vis them, the way they have accepted it, then because they say I have not failed in technical bid. Till now, they have not disclosed so. And so far as respondent number 6 is concerned, they say insofar as experience is concerned of some unit of theirs, which is the concerned unit, they have produced documents and that they have accepted. So whether again that would be acceptable would be the cause of action. I mean, that may
All understood. So therefore, your case is that the entire thing should go, or only your technical bid should be qualified?
my
is your
ground,
case?
my lordship, my ground for rejection. My ground for rejection, if made known to me, I would know what the thing is all about.
Let's see an extra Q.
An extra Q, my lord.
What is your name?
MSMBO.
MOM. You're not there.
No, I'm not there.
Where are you?
This is where respondent number 5 and respondent number 6, they have been given the marks position 1 and 2.
We found that the 4 bidders, 2 bidders are technically eligible and the marks with position is as follows. Technical marks out of So they say that out of, they have to get 60.
60.
60.
60.
Then they will have technical, the minimum eligibility.
Minimum eligibility.
For technical mark out of 70, then there is further another thing. Oh, let's see the,
The requirement is at page 50.
you are informed that your bid for the above tender has been rejected during technical evaluation by the duly constituted committee for the reasons technically not qualified. Okay, now, why the second repetition?
Second repetition is my rejection. First, hotel, the houseboat was not incorporated. During the process, this came up. They accepted my participation.
Summary report and it's R.
They said there were 4, we said there were 9.
Rejected technically not qualified. This you are challenging. Why? So you are challenging an QNR.
Yes.
And for seeking a mandamus for direction of publication of the broadsheet. That's all.
Page 94.
That's okay.
That's okay.
Now, what do they say about the broadsheet? What is that clause 17.2?
My lordship.
Where is clause 17.2?
My.
All technical bids shall be scrutinized by a technical evaluation. The evaluation shall prepare a broadsheet of all relevant technical features submitted by different bidders for consideration and evaluation by the. So do you want this one?
No.
Now you don't have this.
My lordships.
Do you have the technical broadsheet? No.
No.
Yes, government. Who is appearing? You are appearing.
For a moment, if I may indicate, page
Yes,
50.
your lordship.
Where is the technical broadsheet?
Lordship, I have to take instructions with respect to the technical broadsheet, but if I may get permission of this
Why
court,
are you filing this IA business?
I have filed because lordship, this matter has been pending for last 3 years.
I am asking you, why you are filing means you are should be ready with your matter.
Lordship, if I
And then
may,
you have filed the IA on the ground that the matter has been delayed. There is an interim order, so you require vacation of that order, but you don't know what is this technical broadsheet.
technical
What is
broadsheet,
17.2?
technical broadsheet, your lordship, it is only
Produce the reports.
as far as the matter is concerned, it is
Madam, we will have it tomorrow. Produce the records.
much obliged, your lordship. Much obliged.
List the matter tomorrow. The council appearing on behalf of the respondents shall produce the authority shall produce the records.
Much obliged.
Yeah.
Wait for a minute.
For admission item 18.
What is the matter about?
The restoration of electricity connection as well as setting aside of the notice for disconnection of.
Then?
We have received an objection from the defendant, respondent of file. Therefore, we have issued a notice to produce the documents. Ownership proof.
Have you filed the affidavit?
No.
You don't want to file the affidavit?
My lord, is the person will file the affidavit. We'll file it.
You filed?
No, my lord, we'll file it, my lord. Is the person not?
Why you are not filing it? Why you are not filing? 2018 matter means you want a decade should pass by. Then you will file it in 2028. Maybe. That is the reason why the petitioner is so unhappy. What is the petitioner challenging? So have you put the granted him the electricity?
My lord, then I have sought for instruction, my lord. They have asked me from sometime, my lord, they will apply.
Okay, 2 o'clock. Take up the matter at 2 o'clock. Huh? Petitioner was already died.
Right on 25/11/2023.
How do you know?
I am respondent number 5.
Who are you? You have any relation with the petitioner?
Yes,
How?
I am the landowner of the premises where he wanted to take the lease. The title suit was pending before the last.
Then?
In, when the execution was done after this day, and his family members were evicted on 11/10/2000.
Evicted?
Yes.
From these premises?
Yes.
So therefore, Mr. So-and-so, the learned counsel appearing on behalf of the respondent number 5 submits that in respect to the premises wherein the petitioner have sought for electricity, the petitioner was a tenant of the respondent number 5.
No, he was not. He was forcibly occupied by.
The petitioner had forcibly occupied the said premises of the respondent number 5. Pursuant thereto, a suit was filed by the respondent number 5 seeking eviction of the petitioner, which was the said suit was registered and numbered as title suit number 308/2009. Pursuant to the decree passed in the said suit, the petitioner have already been evicted. Petitioner as well as his dependents have already been evicted. It therefore appears that the petitioner is not represented today, and as such not interested. Considering the above the instant proceedings, that's closed for non-prosecution. Mr. Das, RJ Das, I'll fix it on 4th. 4th. I go to 4th.
Item 19.
Mr. Third, why whenever you appear, the other side appears, they appear?
My lord, the thing is that they have already got the relief.
Mr. Ardhar, or is it something like that, that when Mr. Ardhar appears, the respondents, he advises the respondents to give the justice which a petitioner requires. Something similar. Because for the last week and to this week today, and it starts today, there are many matters where you just make the submission, my lord, the petitioner have already got the relief.
My lord, at least I advise my client.
Yes. But kindly advise your client to give a better copy, which is more lazy.
No, my lord, I just got pinned out from this office only.
The none appears on behalf of the petitioner on call. Mr. Ardhar, appearing on behalf of the Handloom and Textile Department, submits that the petitioner have already been granted the relief for which the instant with petition has been filed, and in that regard have placed before this court an instruction which is kept on record and marked with the letter X. Also taking into account that the petitioner have already been granted the relief, nothing further remains in the instant proceeding for which the petition stands closed.
20.
Make Ms. Lustig on the back.
Yes, madam. Entitled, not entitled.
Very urgent.
You're going to pay. How much? 6 months? 6 months. So you, on affidavit, you have stated that he is entitled to. Affidavit has been filed by somebody, na, respond number 2. No, as of now, this affidavit did not say that he's entitled to.
My lord, during the pendency of the case, final bill amount of 5,24,084 rupees has been paid. However, the security amount of 4,53,745 rupees has not been paid. During
You
the,
have not got 4,53,745.
my lord, security amount.
You have
Security,
not got it.
my lord,
You have got 5,24,000.
my lord, the final bill amount we have received.
Okay, so security deposit. So you pay within 4 months. Itu for ini लिखी दीपो. Ini लिखी दीपो case to pay file to Ms. So-and-so, the learned counsel appearing on behalf of the petitioner submits that during the pendency of the writ petition, the final bill of the amount of rupees 5,24,084 have already been paid to the petitioner. However, the security deposit amount of rupees 4,53,745 have not yet been paid, in spite of completion being made to the satisfaction of the respondent authorities. The learned counsel appearing on behalf of the respondent submits on instructions that the file have already been processed for release of the security deposit of the petitioner. Full stop. However, the release could not be effected due to delay in receiving the no liability certificate from the district. It was also have placed before this court an instruction dated 23/7/2025 issued by the consultant National Health Mission, Assam. In terms with the same instruction, it has been mentioned that the file as regards the payment of the security deposit has already been processed. It was mentioned that it was further mentioned that there was a delay on account of non-receipt of the no liability certificate from the district. However, as the no liability certificate have already been received, the security deposit would be released soon. So taking into account the above, this court disposes of the instant writ petition, thereby directing the who is the national? Whom should we direct? Project director, mission director. Directing the mission director, National Health Mission, that is the respondent number 2, to release the security deposit of the amount of rupees 4,53,745 within a period of 2 months from the date a certified copy is served upon the respondent number 2.
No liability certificate has been issued.
That I mentioned it.
22.
About me leaking. Yes, what is this?
Lordship. Lordship, it is a tender matter, Lordship.
You have not got a stay.
No stay, Lordship.
Tender of what?
Fishery, Lordship.
Oh.
7 years tender, 5 years has already been done.
Then what do you mean?
I was not awarded with the contract. And the respondent number 7, private respondent number 7 was awarded with the work in spite of his having Bakijai liability of 9,25,000. And that was being placed by the authority, by the report of the ADC and by the report of the Fishery Department also. In spite of all this, the tender issuing authority has disregarded the thing and awarded the work to him, although he was first bidder and I was the second. After
you are the highest?
No. He was the highest bidder. I am the second. Actually, he was not the first. Due to cancellation of other bidders and due to withdrawal of some other bidders, lastly, he was the first. I am the second.
Who is appearing for the government? Fishery Department, you are appearing. Mr. P. Sharma, not there? It's okay. Now tell me, why did you allow without the Bakizai notice?
Paragraph 9, my lord, we have stated now.
Paragraph 9 of the.
Our affidavit says 45 minutes. That's all.
Ground for rejection of the tender of the petition is legal and valid as a petitioner initially submitted in valid affidavit certificate. Or later on after the last date of submission of the affidavit supplementary document. So you were also technically disqualified.
No, Lordship. Lordship, I'd like to submit, Lordship. Initially, on the day of submission, I had submitted the Bakizai certificate.
Wrong one.
It was in my personal name. He was the secretary. And subsequently, in the name of the society, he was the secretary of the society. It was his personal name. Subsequently, he has submitted the Bakizai certificate in the name of the society, wherein he is the secretary, Lordship. And that was accepted, Lordship. That was accepted, Lordship.
What about his Bakizai proceeding problem?
Lordship, page number 32 may kindly be seen.
No. What is your reply to this allegation? He is saying that the amount of rupees
9,25,000
was pending, which the respondent number 7 had to pay to the authorities. In spite of that, you gave him the contract. Why? What is your justification of that?
And whether or he has given money. So
No. Not the case of the petitioner. You may not have read it properly. His submission is different. Yes, what you are anxious to say.
Regarding my Bakizai system. But it was verified. There is no any Bakizai. There is no any Bakizai. Case against law agreement.
Where do I get this?
Can this my quarter submission? There is no Bakizai.
Well, there you must have
That's 25 man, this petition man.
page 25.
Yes, ma'am. This is not my bid value 15 lakh and this one bid value man 8 lakhs 9.
Yes, from the scrutiny of the tender documents with the views of who got it? Respondent number 23 Borpani.
Yes, ma'am.
Borpani.
27
Where is Borpani? 23 units. The offers, the bids offered by man.
It's 27.
You quoted how much? You are, what is your name?
What
is his name?
Nihari Haria.
Nihari.
8 lakhs 9,000.
Nihari.
5 lakh difference.
You quoted 15 lakhs. Isn't it? And he quoted 8 lakhs 9,000.
Yes, ma'am. Regarding what addiction man says 20.
His certificate. And then others were also there, na?
Yes, ma'am.
Highest bidder withdraw. Second is him. Third is some Kolong Nodi. He quoted 9 lakhs and found to be valid. And then 9 lakhs. So now you want to give this 2 lakhs for 2 years to whom?
To me, Lordship.
Not to you. You are fourth.
No, Lordship. Ultimately, I am second.
How?
Others said Lordship will find.
No, he was valid, na? This Kolong Nodi.
No, Lordship.
Yes.
All have withdrawn.
Withdrawn subsequently. No, page 25.
Only 3 valid. 3 tender is valid, ma'am.
Ah.
Yes.
Now one is Nogao.
Yes.
Second is Yo. Third is third highest is one is Nogao. Second is here. Here at rupees 14 and third highest That is, Iman is 9 lakhs. Is 7th highest.
Regarding the public right?
As per the inquiry report number 4, and report inquiry and the report of ADC, there is no record of any Bakizai dues against you.
And thereafter, my lord, subsequently, my lord, we approached regarding the Bhaktijai, we approached the AFDC, my lord. FDC submitted a report with there are 21,000 something, there is no. And we already paid. Well, it my family pays 27. There are no any Bhaktijai against me, my lord. It's 27. Sorry, my lord.
Who is Padmakanta Biswas?
But till 26 of the subsequently, you can say my bidder, right of this one, the petitioner objection, my lord, regarding my package, the first bidder on the grounded report of the government, revenue of the another decision. Text condition method. We say first bidder. I am the first bidder. Text condition.
Subsequently, the second highest bidder raised objection against the first highest bidder on the ground of default of students.
Yes,
Who is the first highest?
I am the first bidder.
You are not the first highest. You are the third highest.
My lord, last, consequently,
After withdrawal, we became
Withdrawal.
first and two.
withdrawal, all the she has really bidder and where I am the first highest bidder.
I am the second.
And the best condition, my lord, the state first, I bidder submitted representation delegation that the case has been registered showing the Bakizai deal against the error property deal to the Kodai district. I was the LSC, the Kodai district, the error on that. And 29 lakh 25,040. But my lord, personally,
And Mr. Counsel,
Lord-
why are you saying that there is dues on what
Yes,
basis?
Lordship. Only I would like to place two documents. Page number 32 and page number 37. Page number 32, Lordship may kindly see annex of 7.
Yes.
I would like to read out, Lordship. That this office, in this office, bearing this Bakizai case was registered in this office, bearing number 1/20 against Chandrakanta Biswas, Chandrakumar Biswas, in respect of Irakopili bill, there is a same society, which liability for the year 2018-19 to 2020-21 for an amount of rupees 9,25,740. This is one document, Lordship. Secondly, Lordship, page number 37, annexure 10. It is issued by project manager. I see this, yes, for development, Fishery Development Corporation, Lordship. Herein also, with reference to that is
Page-
regarding status report, Lordship.
36.
37, Lordship. It is just subjected status report in respect of Irakopil, Lordship. It is written that I found that under my office record, Chandrakumar Biswas has been liable to pay rupees 9,25,740 only for the year 2018-19 to 2020-21. Lordship, these all
these document, my lord, after this document, which was in lost FIR against them, my lord. This signature was not managing director. Managing director intimate me, I can my FPO reply, my lord. I only 9,000 something that was paid in my reply, my lord. Here is schedule, my
two report, Lordship. One is ADC and one is the Fishery Department.
AFTC authorized person, my lord, intimate me, I was to pay 20.
How do this court look into which is true or false?
Lordship.
In my reply, my lord.
How do this court look into what is true or false?
Oh, yes,
which is-
Lordship, Lordship, that the false is their contention, but true is the report of the ADC, Lordship. Certainly, false is their contention, that ADC is this is false, but it is not my document, Lordship.
Now,
They have,
Bakizai certificate is required from whom?
Lordship,
Bakizai certificate is required for whom?
from DC, Lordship,
Understood. From whom? From whom?
from the society, Lordship.
Society. Now, those documents only say about some Chandrakanta Sharma or somebody.
Chandrakumar Biswas, this Irakopili bill, Lordship.
Ah.
That is, he is the this respondent number 7, Lordship.
He's not the respondent number 7. Respondent number 7 is a society. That is why you had the problem.
He
You
is
are, no,
yes, Lordship, represented by his secretary, Lordship.
maybe he may be the secretary. But the fact is the Bakizai clearance certificate has to be against that society. Isn't it? That is why you were asked to submit the second one.
Yes, sir.
Which you had in favor of your society.
Yes, Lord.
You submitted, they did not accept it.
Yes.
Later on, you submitted for the society.
It is, Lordship.
Now, for the society, whether there is any dues.
In respect of the Irakopili bill, Lordship, it is written.
Is it for the society or the secretary?
No, not for the secretary, Lordship.
Let's read it again.
Lordship, this page number 32, Lordship.
Page number 33.
32, Lordship.
33. 33.
32 is translated.
Against Chandrakanta Biswa in respect of so and so. Not the society. Again, you see the next one. Against Chandrakanta Biswas, ex-lessee. So it is in the name of that secretary, not the society.
Of course, Lordship.
No case.
But in respect of this Irakopili bill, Lordship.
Maybe. Therefore, you were also asked to submit that we are not going to accept the Bakizai certificate of your secretary, but you have to give for your society.
So they have
Because the society has to claim, isn't it?
Yes, Lord.
Who would be the lessee? Can there be a person by his own self can be a lessee? No. It has to be a society as per the fishery rules.
So they have not even submitted, Lordship. I am submitting that they are having dues. And they have not submitted this Bakizai clearance, Lordship.
I have no any Bakizai certificate, madam. How I submitted, madam? Is defaulter, is Bakizai certificate.
How?
All the document I submitted, my lord.
Now, is it the requirement that you have to submit?
Yes,
the
Lordship, as per the tender document.
Huh?
Okay.
He has submitted.
Yes, my lord. In water, my lord, can you see water sheet, my lord? In the water, my lord. Clearly stated, my lord. All the document I have submitted, my lord.
Then?
That's 27, my lord. Period, my lord. The adequacy is in best, my lord. Only the report is itself reflected, my lord. Best condition, my lord. This allegation is fact. Best condition second by my lord. This photo is the APR the earlier than year 60. The best basic result dated sponsor was not completed.
And in page 26, Lordship, in the impugn order, settlement order, the authority has clearly written specifically that they are having dues, Lordship. In page 26, para class but 1, Lordship.
Where?
It is from the report, Lordship.
Where?
In the report, Lordship. In page 26, Lordship.
Read.
As regards Bakizai dues against society, ADC Nagaon in his report stated that there is no Bakizai case against the society in Nagaon district. And it seems that Bakizai said is registered against the society for rupees 9,25,740 in respect of Irakopili fishery with liability for the year 1819 to 2021, which we have referred, Lordship. That has been.
But that has been rejected, na? Mr. Council is doing this type of stuff.
That is why, Lordship.
Hello, let me come back at 2 o'clock and to do the final rights of your matter. Of the parties and have perused the materials on record. From the materials on record, it is seen that the respondent authorities and more respondent authorities had visited the petitioner's establishment on 30/6/2023. 23, na? 23. On the very day, the respondents, without issuance of any notice or otherwise, had imposed the penalty in terms with section 404(1) of the Guwahati Municipal Corporation Act 1971 as amended by the Guwahati Municipal Corporation (Amendment Act 2021. It is pertinent at this stage to take note of section 404(1) as was inserted, as was substituted by the Amending Act of 2021, and the same is reproduced hereunder. A perusal of the above quoted provision would show that the action which is contemplated under section 404(1) is in the form of a penalty / fine. And there is also a discretion conferred upon the respondent authorities as to how much fine should be imposed per day, in as much as the term expression used is inverted comma, which may extend up to rupees 5,000 per day, inverted comma close. First, in the opinion of this court, the said imposition of rupees 1,50,000 upon the petitioner by the respondent authorities, that too without passing an order, is completely contrary to section 404(1) of the Act of 1971 as amended by the Amending Act of 2021, and further is also in violation to the principles of natural justice. It is the opinion of this court that when an authority, statutory authority, imposes a fine or a penalty, the imposition of the fine or penalty should be preceded by an order. There is no order placed before this court by the respondents in filing the affidavit. The said action of imposition of the fine of rupees 1,50,000 as a fine is, in the opinion of this court, is an arbitrary and an unreasonable action, apart from being in violation of Article 21 of 19(1)(g), 19(1)(g) and Article 21 of the Constitution. Accordingly, this court disposes of the instant writ petition with the following observations and directions. Number 1, the imposition of the fine of rupees 1,50,000 upon the petitioner by the respondent authority which is not preceded by an order and without issuance of notice is interfered with. This number 2. This court directs the respondent authorities and more particularly the respondent, the Commissioner GMC, to refund the amount of rupees 1,50,000 to the petitioner within a period of 2 months from the date a certified copy of this order is furnished to the respondent Commissioner GMC. Number 3, this court permits the respondent GMC to initiate action against the petitioner if there is any violation to the provisions of the Act of 1971. And if so, and thereupon take due steps as is provided under law. With the above, the instant petition stands.
Your Lordship, my lord, on Friday, I have filed an additional affidavit. This is not an honorable court record, my lord. I have filed an additional affidavit on Friday, last Friday. This is not an honorable court record.
MD Bora, the Learned Council submits that an additional affidavit has been filed on behalf of the Transport Department. However, the same is not on record. Mr. Sharma, any urgency? No, sir.
My lord, actually, yeah, necessarily pending. my
Matter
lord, regarding
pertains to what?
Date may, so date may be kindly fixed. my lord.
Huh?
So date may kindly fixed. Otherwise, if your.
There's no urgency.
No urgency there.
Okay. So we listed on 11th of August 2025, along with the SEDA. In the meantime, the petitioner would be at liberty to file any reply if so advised.
I have your Lordship in this matter, your Lordship. I am not in a very good position. I am not in a very good position so far this case is concerned, your Lordship.
Very good.
In fact, your Lordship, there are several grounds on which my tender was rejected. If one of that ground was your Lordship neighborhood certificate, not has been issued by concerned Gaon Pradhan instead of concerned revenue circle officer. Now, your Lordship, that was one of the grounds, your Lordship. And in fact, in this ground alone, my case will have go, your Lordship, because your Lordship, on this point, your Lordship, there was an gazette notification. That gazette notification, your Lordship, says that it will have to be issued by the circle officer, neighborhood certificate. Now, it also said, your Lordship, that this clause will have to be included in the advertisement. Now, Honorable Single Judge in one of the cases, your Lordship, held that it will have to be there in the advertisement. In my case, it was not there. But that was, your Lordship, that the judgment was overruled by the division bench and ultimately upheld, division bench order is upheld by the Honorable Apex Court. After that, your Lordship, probably nothing remains for me to, on that count alone, your Lordship, my bid will have to be rejected.
So your case has prepared the insert to challenge the order of settlement.
Lordship, granted in favor of the private.
60% category has
Rejection of my bid.
For a period of 7 years that is offered bid of demand. When senior appearing on behalf of the head submitted that question to the order of settlement, the respondent of has already taken over the event and senior counsel has been reached. What is your case?
My case was, your Lordship, that first of all, one of the point was that neighborhood certificate, since it was not part of the, who would be the authority to issue the neighborhood certificate, therefore Gaon Pradhan's certificate need to be accepted. That is one of the ground. And second, other ground also, your Lordship, that Bakizai clearance certificate was in the name of individual, not in the name of that. I have submitted that Bakizai certificate as per our High Court judgment is not essential. There is one judgment. And your Lordship, experience certificate is in individual name of each member instead of SHG as a whole. Certificate was issued, your Lordship, not as a whole, but each of the certificate was issued in respect of each of the members. That will substantial compliance in my humble opinion. These are the basically grounds, your Lordship. But this, when this goes, your Lordship, everything else goes away. But neighborhood certificate is good.
most important document so far as this area.
So you didn't have a neighborhood certificate,
Neighborhood certificate issued by the Gaon Pradhan, Your Lordship.
but it has to be by the
By the circle.
circular. And that was directed as per
As per there is a
office memorandum.
not office memorandum, Your Lordship, gazette notification.
When?
That, Your Lordship, right now I don't have, Your Lordship. It was not mentioned in the advertisement also, Your Lordship. Oh,
Any idea?
2019.
And when was this?
Oh, it is here. 18 January 2018. Your Lordship. Your Lordship will find accordingly, it has been decided that following clauses are to be included in the notice inviting tender.
Issued by the ARC indicating all the members of the area are fishermen, actual fishermen belonging to the scheduled caste. It has to be given neighborhood certificate is by the concerned revenue circular. So that was holding the field. Heard Mr. S. Otaku, the learned counsel appearing on behalf of the petitioner. Ms. Yudas, the learned counsel. Additional senior government advocate appears on behalf of the respondent numbers 1, 2, and 3, and Mr. So-and-so appears for the respondent number 4. The petitioner has challenged the rejection of its bid. Dated.
Your Lordship will get it at page 60, Your Lordship.
No, it's
Very first. Dated 28/8/2023.
By the order dated 28/8/2023. It is relevant to take note of that the bid of the petitioner
I was the second highest bidder.
was rejected on various grounds as enumerated in clause Roman 1 to Roman 7 of the order dated 28/8/2023. One of the grounds which have been mentioned is that the neighborhood certificate was issued by the Gaon Pradhan instead of the concerned revenue circle officer. It is pertinent to take note of that by the notification dated 18/1/2018, which was published in the Assam Gazette on 4th of April 2018, it has been categorically mentioned that the neighborhood certificate has to be issued by the concerned revenue circle officer. Without going into the other grounds on which the petitioner's bid was rejected, on this ground alone, it is seen that the neighborhood certificate, which is a mandatory condition, having not been issued by the competent authority, the said neighborhood certificate which was submitted by the petitioner society was not as per law. Considering the above, this court finds no ground to interfere with the order dated 28/8/2023 by which the petitioner's bid was rejected. Accordingly, the instant petition stands dismissed.
Deeply obliged. 28.
Yes, Mr. Klam.
This is non-payment of bills, my lord. The petitioner was done some works in the Panchayat election, my lord, in 2013. And till date, my lord, the payment has not yet been made, despite the fact that the deputy commissioner has admitted the same. And now the commissioner, my lord, has taken a plea that the original.
Huh? You filed your affidavits?
My lord, affidavit filed. The deputy commissioner as well as the commissioner of the Panchayat.
What do they say?
My lord, deputy commissioner has admitted the amount of the petitioner. But the commissioner said that they have sent it the bills to the finance department, and finance department makes some queries regarding that the original bills and vouchers, which has not been forwarded by the deputy commissioner. But subsequently, my lord, in the order that has been reflected, my lord, in the 18/6/2025, the learned standing council has clarified that the vouchers and bills has already been sent in the year 2018, my lord.
Then
This matter has been listed, my lord, now today.
But also, no any pending bills that is this matter. It's not found in our department. So that's it. If they submit the bills, then kindly the receiving company will submit.
Madam, how can I pass that order when earlier Ms. Yudas, appearing on behalf of the respondent, submitted by the letter dated 16/6/2025,
Yes.
which was issued by the district commissioner, stating that the required original bill, vouchers and other relevant for the Panchayat election 2012-13 had been already submitted to the Commissioner Panchayat and Rural Development Department by letter dated 5/1/2018. Let us see the bills, how it is. And how did you order? So here the district commissioner duly accepts it in the affidavit.
Yes, my lord.
And the affidavit which has been filed by the respondent number 2. Madam, what you are submitting, I don't think you must have read the affidavit filed by your person.
That's it. We have filed the affidavit also.
Understood. And you have filed, but you have not read the affidavit, it seems.
That's it. Kindly.
Kindly come to paragraph
Somebody-
5.
That's it.
What does it say? That all these things have been placed before the finance department. And after receiving the validated bills, vouchers, the office of the commissioner will submit the paper before the government. On intimation from the government, the respondent number 2, Commissioner so-and-so had issued letter to all concerned, Iman so-and-so, for submission of validated bills, vouchers relating to pending bills. Now the question is, because of this affidavit, there was a direction to take up with the district commissioner. District commissioner says that on 5/1/2018 itself, we have submitted to you. Now,
But not only they found in our department.
then you have to fight it out between yours.
Yes.
Why should the petitioner suffer? Tell me. Somebody of your officers must have lost it.
Standard of the court.
Yes. Then what to do? Both of you settle your dispute
That's it.
and then revert back to this. Both of you have to settle. He cannot be made liable because of your inefficiency on behalf of your departments. The petitioner herein have filed the instant petition claiming an amount of rupees 18,64,649, which is due to the petitioner on completion of the works relating to the Panchayat elections held in the year 2013. The record reveals that the Deputy Commissioner South Salmara had filed an affidavit in opposition, stating inter alia categorically admitting that as per the official records, the outstanding bill in favor of the petitioner is rupees 18,64,649, and the payment would be made after receiving the fund from the government. Full stop. On the other hand, the commissioner of the Panchayat and Rural Development Department had also filed an affidavit in opposition, wherein there is no denial to the amount which is claimed by the petitioner, but it is being submitted that the matter, that the documents, that the claims in respect to the Panchayat election have been forwarded to have been placed before the Finance Department. And the Finance Department had raised queries as regards the original bills and vouchers were not certified from the most senior secretary of the department. Full stop. It is under such circumstances that the respondent number 2 had issued various letters to the district commissioner and subdivisional officers for submission of validated bills of vouchers relating to the pending liabilities. The record further reveals that when the matter was listed before this court on 18/6/2025, Ms. Yudas, the learned additional senior government advocate, had placed before this court a communication dated 16/6/2025, issued by the District Commissioner South Salmara, Mankasa, wherein it was categorically mentioned that all the original bills, vouchers, and other relevant documents for the Panchayat election 2012-13 have been submitted to the Commissioner, Panchayat and Rural Development Department by letter dated 5/1/2018. And it is under such circumstances the matter was placed before this court, have come before this court now, it is under such circumstances, the matter has been directed to be listed today. Full stop. This court have duly heard the learned counsels appearing on behalf of the petitioner as well as the respondents. From the materials on record, it appears that there are certain interdepartmental confusion between the office of the district commissioner as well as the Panchayat and Rural Development Department in respect to the original bills, vouchers, and other relevant documents, which is the basis on which the petitioner claims the amount. On one hand, the district commissioner states that all these documents have been already forwarded on 5/1/2018. And on the other hand, the commissioner, PNRD, again insists upon the same. It is the opinion of this court that the said departments of the respondent, that is the office of the district commissioner, South Salmara, as well as the commissioner, as well as the Panchayat and Rural Development Department is required to arrive at a conclusion in as much as on account of their laxity, the petitioner cannot be permitted to suffer. To list this matter again on 1st of September 2025, on which the councils appearing on behalf of the respondents shall give an update as to whether they have arrived at a consensus.
Much of
29.
Item number 29 and 30. I took time to file affidavit in the matter. But because of a circumstances in the time, the commissioner food has
Non-payment.
recently joined. But I prefer 3 days time. He has very recently joined, because of that, I think, finally.
So you want,
I therefore ask little accommodation, On last occasion, Lordship has given time and observed that Lordship has given us last opportunity to file the affidavit. Well, here the affidavits are ready, and in fact, one of the issue which the petitioner has raised, one of the claim, it has a far-reaching effect, one of the.
when you are filing the affidavit,
Not the,
you have not filed the
we
affidavit.
have not filed one of the.
No, we impose a cost. Last opportunity, how do I escape that
Kindly consider.
upon you?
No, he has very recently joined.
25,000 upon you.
Kindly
Let the
consider.
District laws, district legal services authority benefit at the cost of Mr. Dipankar Nath.
2 days or 3 days time, but kindly accommodate, he had joined on 23rd of this month.
It has been submitted by Mr. Dina, the learned senior government advocate, that the affidavit is ready, but on account of the transfer of the official who is to file the affidavit, the affidavit could not be filed today. Could not be filed. So list this matter again on 13th of August 2025, It is observed that if the affidavit is not filed, this court shall proceed with the disposal of the writ petition on the basis of the materials on report.
Item 30.
29, 36.
Same. Same.
31.
May I, Lordship, in this case, Lordship, I am to file affidavit in reply, Lordship. And it is ready, Lordship, but the petitioner is.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner.
Lordship.
Earlier you have taken time.
It is ready, Lordship. He is in Lordship Chennai due to his illness, Lordship. He is to sign the Lordship.
Huh?
He is in now Chennai, Lordship, for his treatment, Lordship.
The learned counsel appearing on behalf of the petitioner submits that the affidavit is ready, but affidavit in reply to be filed is ready, but on account of the petitioner, being at Chennai on account of his ailment, the said affidavit could not be filed. This list of matter again on 20 August 2025. Now list the matter after the filing of the affidavit in reply.
32.
By the petitioner.
Yes,
Yes,
we got some time to file our affidavit, madam. We could not file our affidavit because we do not receive the penalty punishment. Only the day before yesterday, we have received the punishment for filing the affidavit, madam.
You want to file affidavit?
Madam.
Mr. Nancy does, the learned senior counsel appearing on behalf of the respondent submits that a final chance may be granted to file the affidavit in opposition. List this matter on 8th of September 2025, a final opportunity is granted to the respondents to file their.
33.
Please, Your Lordship. But in this case.
Yes,
my lord-
madam.
My lord, the petitioner was awarded with some work under Jal Jeevan Mission. Some 16 work order regarding 16 my lord, units, he was allotted with the work order. Now, by way of this impugned order, my lord, 5 of the work order has been withdrawn. My lord, and this order has not been communicated to him. He got to know this cancellation order from a WhatsApp group, my lord. Now they have filed their affidavit.
Why nobody is there? Respondents? PHE none appears for the PHE department when the matter is called for, For the ends of justice, the matter stands adjourned to be listed again on the 3rd of September 2025. it is observed that if the PhD department is not represented on the next date, this court shall proceed with the disposal on the basis of the materials available on record.
35.
Yes, what is this?
What's it?
Not getting a good place in, these are all fishery.
No, my lord, the petitioner have the sub wholesale license holder, my lord, of cooperative society.
Notice have been issued to the Gujarat till date in violation of section 15(2) of the Assam Public Distribution Regulation. You have been suspended
Yes, my lord,
and your suspension is going on.
the suspension is going on. We have challenged that suspension order on the strength of, my lord, section 52, subsection 2 of the, my lord, PDS article order 1982. That is, I have quoted in my petition also in paragraph 13, page 17, my lord.
Yes, madam, what is this?
We have received the so-called within time frame, madam. We have received the so-called within time frame, madam.
Now, what have you done?
Find our affidavit, madam.
It's okay. So far you have issued. What have you done as regards the decision?
But, for cancellation, my lord, he has approached this honorable court, madam. We have issued the notice also so far on cancellation, my lord, and they have approached this honorable court, madam.
Is there stay?
Yes, my lord, the stay is there, my lord.
What?
My lord, no, sir, courtship action.
Oh, then?
My lord. Now, my lord.
Then in that case, if there is the stay, tell me how on one hand you have obtained a no coercive measures. We modify that no coercive measure and say that let them take a decision on your show cause notice. On one hand, you cannot challenge the show cause notice, the suspension. On the other hand, obtain an order of no coercive measures. If they have taken, otherwise they can very well take a decision.
My lord. And
Then
my lord,
they are not. We allow them to take a decision in the matter.
We are pleaded here, my lord. The state show cause notice issued after the mandatory period of 90 days, my lord.
Understood, but show cause notice has been issued to.
Issued, but after mandatory period, my lord, which as required section 15, subsection 2 of the PDS article order 1982, my lord. What is,
No, you see, a show cause 15(2) say the reason why 15(2) is there is this. That you see, these are public, these are fair price shops.
No.
And if these fair price shops are connected with ration card holders. So therefore, if these fair price shops are closed, then the people will be affected. So therefore, within 90 days, the entire process is required to be completed. So therefore, 15(2) comes into the picture. Let's read 15(2). Where's 15(2)? No order of cancellation shall be made unless this clause, unless the licensee has been given reasonable opportunity of stating his case against the proposed cancellation by an order. But during the pendency or in contemplation of a year, the license can be suspended for a not exceeding 90 days without giving any opportunity to the licensee of stating the case. But as of now, they have issued a show cause notice to you on account of the coercive measures being not taken. We do one thing. Have you submitted your reply
yes, my lord.
to the show cause?
No, my lord.
Show cause, have you submitted the
Show cause,
reply?
received by-
Unnecessary making this matter long does not help you.
My lord, in this case, my lord, senior advocate came to do sir English, my lord. He is in out of station to get
Who?
He and should be. He
No.
is engaged in this case, my lord. One date may be given on that day.
Oh, you are lucky. But this one is not working. Otherwise, I don't allow for senior advocates. Otherwise, you may also say that no notice has been given as regards senior advocate. I don't permit. Anyway, it has been submitted by Mr. So-and-so, the learned counsel appearing on behalf of the petitioner that I would write that. It has been submitted that the learned counsel appearing on behalf, Mr. So-and-so, the learned counsel appearing on behalf of the petitioner seeks for an accommodation to stop list this matter when?
Next, first week of August at any date.
First week of August starts with only one. That means this week. Second week will be starting from 4.
Second week.
Okay, we keep your mind on 1st of September 2025.
August, September, it will so long, my lord.
Huh?
In the August, my lord, second week August.
1st of September.
Second week is September, it will so long. After 2 weeks, my lord.
After 2 weeks, if I say the matter would never come.
But September will so long, my lord.
Huh?
It's so long.
No, it will be listed after 2 weeks. Let's see which will come first.
My lord. After 2 weeks. Master plus.
36 and 37.
Yes, very contested matter.
Lordship.
When we
Is
see
it
Mr.
10?
S. Pinag, I know it's a very contested matter. Yes, what is this?
Lordship, this is a tender matter, your lordship, both these two petitions, your lordship.
Tender,
Tender, your-
fishery.
no, your lordship. This is a work by your lordship, irrigation department, your lordship.
Irrigation.
Irrigation.
There's a stay.
In fact, your lordship, initially there was a stay order.
Stay has
status
been
quo order.
vacated.
No, status quo order.
Status quo vacated.
Status quo not
Not
vacated,
vacated.
but your lordship.
That is the issue, Lord.
Status quo was not vacated. They say, your lordship, that initially, your lordship, when status quo order was passed, your lordship, they have issued a letter to the concerned contractors, your lordship, not to start the work. Thereafter, your lordship, after few days, they again wrote a letter, your lordship, after that status quo means they can go ahead with the work. And accordingly, your lordship, they virtually, your lordship, 3 of the contractors probably completed the work. So far as one contractor is concerned,
Work has been completed.
work has been completed, your lordship, according to them.
Except the petitioner's portion, others has completed, and in respect of another portion, Lordship, another status, another stay order.
Stay order is there, your lordship, in the WPC number 653 of 2025.
651.
653.
51, no stay.
No, status quo, your lordship.
And what
In
is
this-
653?
In 653, so far as one petition respondent is concerned, there is a stay order.
What's stay order?
Respondent number 7.
Status quo order only.
No, your lordship, subsequently, your lordship will find the order dated 10/4/2025.
In view of the till the next date is for no work shall be allowed to be started by the respondent number 6. He has not work started.
He has deposited performance guarantee, but because of this order, Lordship, he is unable to complete.
And who has filed this IA?
I in the second case, your lordship.
One Lordship who has completed, already completed. Lordship.
They want the money, your lordship.
IA has been filed by whom?
I just filed a IA law.
In 651.
An order, status quo was passed. Lord.
Additional evidence.
It already was,
Hmm?
then
What
the
is it?
work order law. And actually the marriage
Additional
was
evidence.
installed in the premise,
Those are the
was,
things,
Now, both the matters pertain to what?
Equivalent.
What is the contract, Mr. Naik?
Lordship, Lordship, I kindly come to, I am in 561, 651 Lord. Case 22 Lordship. Lordship, it relates to installation of 2-point solar powered MDPW scheme. Basically,
Installation of
irrigation
2 points solar power MDH Urul so and so.
Yes.
Okay, then
Case 23. Now, Lordship, initially, technical bid was, technical bid which were, considered. In so far as this contract is concerned, this is project package number 39. In package number 39, 2 persons were found eligible, Lordship. And authority, Lordship, considering all the experiences and performances, Lordship, split the work between 2 Lordships.
That's my challenge.
And that is the ground law.
you are
I am the, your lordship, I am the bidder, your lordship, who has quoted the lowest bid, your lordship.
you were not given.
No, you were also-
Given, your lordship. It was split and one person is given, your lordship. And my case is that, your lordship, that while splitting the contract, your lordship, they have done it arbitrarily, your lordship. That's my case. Cover is there, your lordship, under the tender documents, your lordship, the NIT. They have been given the power to split, your lordship, but your lordship, my case is that while splitting the work, you will have to set out certain formula, your lordship. It cannot be an arbitrary exercise of power. And that has not been disclosed by them, your lordship. Why that has to be split and
Let us see the term by which it can be split.
your lordship will kindly come to page, your lordship is taking up
651.
651. Tender starts from your lordship. Page
You were the lowest
lordship.
and the second person was?
He too. He was
L2. And L2 is Rivraj. He has completed his work.
He has completed. Here.
Now what remains here?
Lordship, that's your lordship, since the both matters are tagged, your lordship. Both the matters are tagged, your lordship.
Understood. If Rivraj has already completed.
Completed the year in violation of the, in my case is that that has been done in violation of the, your lordship, status quo, your lordship.
Whatever may be, but the work.
That has been completed, your
If
lordship.
work has been done, what can this court do now? Only pass that don't do next time.
No, your lordship, that's there, your lordship. Even your lordship, if your lordship go through the second case, your lordship, where your lordship, one contractor is, your lordship, still to execute his work since there is a stay order. Your lordship can always go into the manner in which the entire exercise is carried out by the respondents, your lordship.
Understood. But here, if the respondent, when the private respondent has already completed, means if it is split, private respondent have already completed, your part is remaining.
My part is remaining.
You have not done anything.
No, your lordship.
So therefore, because of the six.
Lordship. Your lordship will kindly see if your lordship can take up 653, your lordship, not 651, where your lordship cause of action, your lordship still survive in respect of another contractor, your lordship. Your lordship can always go into the, in fact, your lordship, on earlier occasion, your lordship, this honorable court has directed my learned friend to your lordship, produce the record, your lordship, to see the, what are the parameters they have, your lordship, taken into account while splitting the work, your lordship. And your lordship will kindly come to 653, your lordship. I will not take much time, your lordship.
Yes. Age.
Your lordship will straightway come to.
Here also that Rivraj.
No,
Because who is the respondent?
In three respondents are there, your lordship.
Now how, this is also being split.
This is also being split. I was the lowest, your lordship.
Now it is being split
Between four persons.
Now who has completed?
7 has completed.
Okay, 7 has completed. Other 3 has not completed.
2 has completed, 1 is the petitioner, and the second one has been restrained subsequently.
No. 653.
Yes, in this case, work was split between 4 lots, amongst 4.
The petitioner and respond number 5, 6, and 7.
Yes.
7 has completed.
The other one is also completed. Out of 4 lots, 2 has completed.
Who has completed? Enough.
Third one is the petitioner. He has not yet started. He has not even deposited the performance guarantee lordship, which as per the tender clause was supposed to be deposited within 15 days. And the third one lordship, he has been restrained subsequently by the Sabha. If in the meantime he has not started, then he shall not start. That was the order.
What is the period of completion? 6 months.
Lordship, for the entire work, it is 6 months. But if it is
Okay, now let's see how it is being done. Where is the clause?
Lordship will kindly come to page 57, award criteria, your lordship. Your lordship, the second one is, your lordship, the subject to approval of the competent authority. The employer will award the contract to the bidder. Your lordship will kindly note that, your lordship, whose bid has been determined as substantially responsible. Naturally, your lordship, that means, your lordship, the only, it is talking about only one bidder, but your lordship, Your lordships may kindly come to then page 59. Clause 3, Roman. Employer reserves the right to split any package and to allot the work among other successful bidder of the package at the lowest accepted rate of the package without intimating L1 bidder. This is the your lordship power they have exercised, your lordship.
So if this power is given, so they are being given at the lowest bid.
Lordship, at the bid at which you my rate.
So,
Lordship, my case is this, your lordship, if this power.
understood, but Mr. Bottakar, one
Lord.
has to also understand, we are sitting in 226.
Lordship.
Public work has to be done. Yes, we are sorry whether your personal interest is being affected, but after all, public interest has to be given importance. The
No, your
problem
lordship.
which arises, yes, you may have lost out, you may have put your, just for example, when you are getting a work of a magnitude of 100, but you are given only 25, there might be a loss of profit and many other calculation expect happen. But it is also, one has to take note of that it is a private,
No, your lordship,
private thing.
your lordship, what has fallen from your lordship's mouth is absolutely
When the
correct.
power is given, to be given at the lowest bid. Because the public interest is not affected.
No, your lordship will have to see your lordship, public interest in the sense, your lordship, that if your lordship, the exercise of that power is arbitrary. That's why your lordship, then your lordship, public interest suffers that way also, your lordship. Arbitrary exercise of power itself.
What is the arbitrariness?
Because your lordship, they have not disclosed, your lordship, why they have split the work, your lordship. Your lordship has seen the award of contract. That's why your lordship, record was called for. Your lordship has seen that when the award of contract is clause 2, your lordship, it specifically uses in singular bidder, whose bid will be substantially responsive. Normal circumstance, your lordship, they will award the contract to a single bidder, your lordship. Now, when you deviate from that, your lordship, and split it out among some bidders, your lordship, there will have to have some criteria, your lordship. What are those criteria? You are neither coming up with this, your lordship. That's why, your lordship, I am submitting, your lordship, that has given.
But why should this court interfere?
Because your lordship, in any arbitrary exercise, your lordship will, as a.
Yes, it has been done, but we are concerned. Yes, it's a long contract, it's a different thing. It's a contract by which, because of this, the contract which would have been finished by now is still at a nascent stage insofar as the package which have been, part of the package which have been given to you.
Lord.
And this is harming the public. These are for public.
That's correct, your lordship. But the point is, your lordship will kindly see.
We will decide when a point comes and time is there for that. But the question is, why should this court interfere with these type of things when the power is being reserved? I've understood. If they give it to a person who is of the higher bid, it's a different thing. Or on the date on which the matter is moved and hearing the other side, on that very day, concerned, this court passes an order. Then look at this, you could not have done, asking them to produce it within 1 week. But we are concerned, not now.
No, your lordship will kindly say, for that, your lordship, petitioner cannot be faulted. Because your lordship, if somehow for.
Faulted, I have all the sympathy, Mr. Bottakar, with you. Petitioner is very sad for that. But the fact remains that we are also concerned that our hands are tied in respect to this.
No, that I understand, your lordship. But one aspect, your lordship will kindly notice.
What is happening, Mr. Bottakar, because of the status quo order, you have also not started the work. And this is going to get delayed by another 6 months.
No, your lordship will kindly see, your lordship.
The lordship, subsequent to the status quo order, lordship, on 10/4, lordship, another order was passed. Wherein lordship, he was granted the liberty to start the war.
Why you are not doing it? Go ahead, do your work. Submit your
No,
performance.
your lordship will kindly see, if they exercise this power, your lordship, tendering authority in this manner, the question of your lordship asking for tender itself has no meaning, your lordship. Because if they can, your lordship, by putting
the lowest bid.
No, your lordship, maybe your lordship.
To fix the lowest bid.
And your lordship will kindly see, your lordship, there is not absolute bar for 226 court to interfere, your lordship. That your lordship knows very well.
Mr. Bottakar, I am telling you, if I was the judge who was sitting in the motion bench, I would have finished it up on that day
That's
or
your
the-
lordship.
within 2 days.
We are unfortunate.
I
that
would
we
have
did
finished
not-
it up because this is the matter which cannot wait. But we are concerned
That is
now
why
that
you-
6 months have passed by.
That is why your lordship may dispose of the matter on merit today itself, your lordship. I will not take much time. This is the only case, your lordship, that how they have, your lordship will
No,
go.
don't worry. It's only 5 minutes for 4 it is now. We'll finish at 4:05. The order.
Lordship, your lordship, I will take hardly 10 minutes, your lordship, not
No,
more than.
your
I have
argu-
already
Your
argued.
argument, I've heard you.
Lordship,
So your question is only that yes, the power is
Is
there,
there.
but when you are exercising the power
That
has
will
to
have
be
to be
exercised
fair.
in a reasonable manner.
your lordship,
Or give justifiable reasons as to why you want to split.
lordship.
You have the power, but that doesn't mean that you are going to do it. When the section rule, this clause 28.2 say, one says that it is to be given to the lowest bidder.
Lordship.
You should have given it to the lowest bidder, but instead of that, you have split. There has to be
And
justifiable.
your lordship will kindly see, I have been given the lowest portion of the work, your lordship. Out of all these, your lordship, had it been a your lordship case that I am given the highest portion, that is not there. I am given your lordship 30%, your lordship, out of the 100% work.
Or 70%.
Yes, among them, your lordship. That now your lordship, that what? And your lordship, they are in their affidavit, they are saying that they have taken certain grounds which are not there in the tender notice itself, your lordship.
But there is also recently a Supreme Court judgment wherein say that the application of Mohinder Singh Gill would not be applicable in respect to these tender matters.
Lordship, that's why your lordship, I have not your lordship argued on MS Gill, your lordship. I have only one judgment to show before this honorable court, your lordship.
Please do. Hey, Kalikita matter.
Your lordship, that is
Thursday.
MP Power Management Company Limited, your lordship.
That was it. Friday, Wednesday, Thursday. Oh, let's look, man. Give December 2025 minutes. Absolutely.
Right.
Okay. We'll take it up tomorrow.
Lordship.
2 o'clock. After I have another matter of 2.
Lordship, tomorrow, your lordship, I will be out of station.
Fantastic.
No,
Then there is no disturbance.
No, your
I
lordship.
passed the judgment.
My son's admission is, I will
Huh?
have to go to Delhi, your lordship, in connection.
When
with
you are
that.
coming back?
On 5th, your lordship. Your lordship will take it up on 6th, your lordship.
Hello, on 5th. What?
Otherwise, your lordship, I would not have taken time, your lordship.
First of all, Mr. Botako, this is not a matter of such magnitude which requires a CAB.
Lord, not
So
good.
therefore, the question is I have to pass the order
Lord.
in the court itself. So this court will pass the order. And what problem Mr. Gore has? To engage somebody else. Because as per CPC, 7 days is enough. So we are giving you 7 days. But the matter having been heard at length is the matter at on 5th of August 2025.
6th, your lordship. 5th, I will return, your lordship. 6th, 5th, I will return you. 6th,
On 7th.
lordship.
On no, 7 very difficult.
6th, your lordship.
6 is no, it's a daily matter. This will require some time. If it was earlier, I could have been difficult. Tomorrow you are not there.
Tomorrow morning, I will.
But the only problem with the Botakur I am having out here is the work being not done.
Lordship, understood.
And by chance, if I dismiss it, I'll dismiss some cost also. That I'm putting you to notice.
Lordship, your
The
lordship.
cost has to be there because of the fact that public has suffered.
No, your lordship, I have come up with your lordship certain legal ground, your lordship. Your lordship may
That
reject
is
it, your
okay,
lordship.
but the-
No doubt
but
about
the-
that, your lordship. I am not,
When it arises out here, that public
I have, and
revenue
your
is
lordship
not
will kindly see the order has been passed by this honorable court.
It looks, Mr. Botakur, it looks fantastic on a legal point of view,
Lordship.
but merely because a legal point is involved. This court may not interfere with that.
No, that is that your lordships can always dismiss your lordship, but if your lordship starts imposing cost on every dismissal, your lordship, then your lordship probably that will your lordship. Because your lordship, they have come up, where will they go? They feel aggrieved, that's why they will come. And this honorable court has passed the status quo order. That is your lordship, I am only.
That was the main problem.
Lordship,
That court should have directed that instead of a status quo, should have directed, okay,
Lordship.
your part, you should. do it.
Lordship.
You have got 30%. First, you complete your 30%. We'll see about the others. Whether some portion of fees has to be transferred out there. That is the question. But your person not to do is because of that you are taking the benefit.
No, your lordship, question of taking benefit, your lordship does not arise. I am not benefited from that, your lordship. Only on the hope that.
Also becomes clear from the fact that he has failed to deposit his performance guarantee.
That is your lordship, that is because your
He is not at all
lordship,
interested.
I was given your lordship, order is 24th, your lordship, on 29th, your lordship. This, I have been given the copy, your lordship, of this preliminary work order, your lordship. It is not that, your lordship, and thereafter I moved this honorable court and the honorable court passes an order of stay. And thereafter your status quo, and then in
But
this,
because of the status quo, the thing is that work has to be done.
then your lordship,
You shouldn't have
honorable
taken
court,
that
your
status
lordship.
quo. It will have an impact on the public works. Anyway, we'll have it on 6th at 2 PM.
Lords. Obliged.
38.
Mr. Bora, you are which side?
I am for the petitioner lordship. My friend has filed an I met.
Means you got so used to it that you are sitting out there, standing on the
Because
side.
I has been today I has come up. That's why I was standing there. No, today I have filed
What
my
is the matter about?
But it's regarding tender of supply of the circuit house, the construction, the certain items.
So somebody has filed an application for vacating.
Vacating, my lord. I have filed my reply today, my lord. Lordship,
filed?
I did, my lord. Will fix a date for doing the entire matter. my lord.
No, we'll fix this matter for taking up the matter for in the state of stay vacating on a Tuesday or Thursday.
Lordship.
And finish it off.
Lordship.
Good job. List this matter in the column of stay vacating on 12th of August.
Lordship.
12th of August.
Lordship.
Matter before Honorable Supreme Court. Well, I have a matter before Honorable Supreme Court.
Yes, I'll help it. Then we have it on 5th of August.
5th of August. Lordship. No, no. I have
Copy for what?
vacating petition has not been served.
Who has filed the stay vacating? He has filed.
Yeah.
Ask him.
I'll serve him.
Both of you, are you sailing in the same boat?
Yes.
Are you not?
39.
On 5th.
Yes, Lozima Court reveals petitioner has not taken steps. Okay, it seemed that the petitioner have not taken steps upon the issuance of directions of issuance of notice upon the respondent number 4. Further to that, the petitioner is not represented for the ends of justice, the matter stands adjourned to be listed on 15th of September 2025. It is observed that if the petitioner does not take steps or is represented, this court shall pass appropriate directions on the next day.
40.
May it please your lordship, in this case, there is settlement issue has been settled between these parties, lordship.
It has been submitted by Ms.
A.B. Castro.
So and so appearing on behalf of the petitioner and or Mr. B Das on behalf of the PTCL. You are standing also that the matter has been settled out of the court, accordingly, the petitioner would not like to press the instant petition. You can accordingly stands closed.
43.
Who is to file the affidavit in reply? You are not filing the affidavit in reply?
I pay for what is time.
Okay.
And the
The 6 weeks time is granted to the petitioner to file the affidavit in reply.
I have another prayer.
No prayer. When you are not filing after taking adjournment, I'm not going to grant any prayer. Sorry, unless you file a 9. The reason is when you have earlier taken an adjournment for filing in the reply, you don't file a reply and now come up with another prayer. No. Give you 6 weeks time, thereafter the matter will come. What is the matter about?
Settlement, granting of liquor license to the respondent number.
Got a stay. No stay.
No stay.
Then
Stay was there, but after the got it. My
have the liquor license sometime during puja.
my submission before the Lordship is
The hot months may not be good.
the name of respondent number 6, that was strike out.
Why?
But there is no post like a principal secretary of the Guardian Minister.
It's okay. Will not pass an order. Okay, Mr. Ashish, 6 weeks time is granted to the petitioner for filing the affidavit in reply. Full stop. The learned counsel, senior counsel appearing on behalf of the petitioner have submitted that the name of the respondent number 6 may be struck off, taking into account that there is no designation of any office as mentioned in as arrayed as respondent number 6. Taking into account this submission, the name of the respondent number 6 is struck off from the records, the counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties within 3 days before the registry of this court, and the registry shall, on the basis of the instant order as well as the fresh memo of parties, making necessary correction of the false title as well as also update in the CIS. Okay, next.
44.
44 to contempt case. You sure? We do 43. To 43 acquisition. 44. No representation on behalf of it. Mr. Bapada is done. Mr. Albert appearing on behalf of the respondent numbers.
1, my lord.
Respondent number 1 had submitted that the order had been duly judgment and order dated
With regard to payment of rupees
23/5/2022 passed in WPC number 3352/2022 have been duly complied with. In that regard, he has placed before this court an instruction which is kept on record and marked with the letter X. Taking into account the above, the instant contempt proceedings stands dropped. We keep this?
Yes, my lord, will kindly peruse the document that I have flag marked, my lord. From treasury, it has been given to the bank. That is the treasury credit. Treasury has credit. And
These are
then
those 2 lakhs.
2 lakhs, my lord.
The beneficiary things. Yes, next.
45.
45, service is not complete.
Not complete, Lordship, on respondent number 1.
You have no urgency. Service being not complete as regards to respondent number 1, who is respondent number 1? Additional Chief Secretary, Water Resource. You have a copy?
Yes, yes.
You appear on behalf of this Water Resource? Understood. Here also they appear for the same. It will be the same. There's nothing different. The direction is for payment of money, I suppose. Mr. Sri Sharma appearing on behalf of the respondents. Number 2 and 3 submits that he is also, he can also appear on behalf of the respondent number 1. First of taking into account the above, the service upon the respondent numbers 1, 2, and 3 is complete. This court grants liberty to the respondent numbers 1, 2, and 3 to file a fresh affidavit, in opposition to the instant proceedings, and accordingly directs the listing of the instant contempt proceedings on 17th of September 2025.
46.
43 also same. Lordship.
Mr. Counsel, you will have a big problem in getting this order. You cannot, they will come up with a plea, they look here, the Jal Shakti is not paying. So why are you not also informing the Jal Shakti? Your contempt will become infructuous. And he's thinking that this is my plea while writing the affidavit, isn't it? And more particularly in view of that review order passed by Justice Sham, and I have also passed a similar order to that effect, that you have a big difficulty out there. Anyway, 46 also same. Same?
7.
46 same? Same order. Here, respondent affidavit filed on behalf of the respondent number 3 file could say 1 and 2 is being given the liberty to file. 3 has already been filed. 47. Lozima order dated observed that the service in respect is complete. Okay, what is the matter?
Lordship, we have been served with a show cause notice regarding non-payment for payment by the Labour Commissioner. Lordship may peruse order dated 6/10/2023. They have not filed the affidavit. The Labour Commissioner has not filed the affidavit.
Miss Yudas, the learned counsel appearing on additional senior government advocate submits that he received that the respondent numbers 1, 2, 3, that the respondent authority shall file the affidavit in opposition. Mr. N.C. Das, the learned senior counsel appearing for respondent number 5 submits that the respondent number 5 may also file the affidavit in opposition if so advised.
And Lordship, regarding respondent number 7, since there is an order of the Lozima court.
7 is not there, 6.
6, sorry, Lordship.
It's performer, we are not concerned. List this matter again on 24th of September 2025.
Interim order, Lordship. Interim order.
Interim order is there.
Yes, Lordship.
Twenty-fourth of September 2025. In the meantime, the respondent shall file the affidavit. First of the interim order passed on 6/10/2023 stands extended till the next date.
Deeply obliged.
48.
Sumoto. What has happened? Sumoto? Who has
There was a
taken-
proceeding before this honorable court, a tender proceeding. Whereas a stay order was granted by this court. But the DFO, my lord, he mistook the, actually the tender was already over. But he issued, my lord, due to misinterpretation, he issued the work order. My lord. But after coming to know, my lord, the court's order, it was cancelled. And now, my lords, we are just tendering apology, my lords. And the,
Why the Sumoto it has been initiated?
on the judicial order, because, my lords, you see, it was, while the tribunal disposed of, my lord, the honorable court saw the officer might have conducted a contact.
Which
My lord, kindly come to Sumoto petition page number 7. This the order dated 2/11/2021, whereby this court has ordered in the interim that at page 9 In the interim, the respondents in the forest department shall not proceed further with the tender process in terms of long e-auction notice under
Until
NIT
further order
so. My lord, thereafter, my lord, on they issued the work order, which is at page 10, 1/12/2021, Annex 3. my lord. Then what happened, my lord? After issuing the work order, another writ petition was filed, my lord. 1609 of 2022. There, my lord, order was passed at page 17, page 22, my lord.
Ms. 13 and Madam Sir, kindly come to page 8.
Eight?
Eight. The second paragraph from the bottom. By the time the petitioner is.
Oh, Mr. Gokul, nowadays both of you don't appear for PHC.
We appear, Malas, I was in court 1.
He?
I don't know where he was, I haven't taken
Well,
this. And
both of you are not there in that case of Nunu Enterprise. Where is that? I remember the name. Which is it? Yes, item 33. I have appeared.
Well, that paragraph, Madam, it indicates that the tender process was over by the time the court has, the petitioners moved to court. Page.
Where?
The bottom second, it is submitted there.
Page?
Page 8.
Yes. Tell me.
It is submitted. The bottom paragraph and the bottom second.
Who has submitted? Where? Page 8 is very difficult.
Page 8 of the petition.
There is, you have, I think, some problem with this. Because here it is not as per petition, na?
This was served to me by the registry, my lords.
Understood. Which order?
Order dated 2/11.
My lords.
Order dated 2/11 has a lot of years, page 8. Then PJ Mohanta, it is submitted that though the letter of intent has been issued in favor of the respondent number 5, but the respondent for respondent has not yet handed over possession of the said Mohol to the respondent and no agreement has been signed. Then
My lord, technically what had happened, my lord, the tender was already over by the time the petitioners approached court. So therefore, my lord, he misinterpreted and we apologize for that also. He issued that.
have you filed your reply?
Yes, my lord, filed. And we have apologized in the original proceedings also. We filed an affidavit.
Where is that?
Original proceedings. Affidavit, my lord.
Filed by?
The LS
Rohini Kumar
Contemporary,
Das.
Rohini Das.
Please look into it later on. Affidavit filed by respondent number. Anything you have to say?
Apology, my lord.
Apology is
He had just 2 years of his job left. And my lord, he was in wildlife. He didn't knew this thing. Again, he has been transferred back to wildlife again.
Huh?
He has been transferred back to wildlife again. Once it was detected, my lord, it is sent back. And my lords, I'm also.
In the affidavit, at paragraph 5 of his affidavit.
We'll do one thing, we'll take it up on some other day.
Well,
This scene. The affidavits have been duly filed in the instant proceedings. To list this matter on 26th of August 2025 at 2 p.m. for further consideration.
49. Problem.
Met. In this case, Lordship, on last occasion, Lordship, my friend has submitted that commissioner, which is respondent number 1, has directed the district commissioner to comply with the order, but till date, Lordship, that has not been
What
complied.
direction? However, with regard to the scheme, Mr. Doctor submitted the commissioner's clearance and directed the district commissioner to take action to in compliance with the review of this order. What is there? What direction?
Direction is to Lordship to inquire, and if any outstanding amount is due, Lordship, that should be paid, Lordship. Regarding contextual bill.
Who is appearing for the district commissioner? The contempt.
Contempt, Lord.
The
District-
problem arises because of this contempt thing.
District Commissioner and the
Who is
BDO,
looking for a district commissioner?
District Commissioner.
Lordship, nobody appears in spite of receiving notice.
Have health service been
Yes,
affected?
On the
Whether
last
this-
notice was.
Madam, you just find out whether this district commissioner is still there. Gayatri Hilagi.
I have submitted one document from the district commissioner only, my lord. What happened, my lord? After the order passed, my lord, we have directed, my lord, the district commissioner, because district commissioner is the head of the DPC, my lord.
Okay. So
Thereafter-
you do one thing, somebody has to appear on behalf of the respondent number 2 and 3.
And three.
Who can appear?
My colleague, for the district commissioner, I can.
Miss Yuda, the additional senior government advocate submits that she will inform the respondent number 2 and 3 about the present proceedings. Also, list this matter again on 3rd of September 2025, comma, and additional copies of the contempt and extra copies of the contempt proceeding of the contempt application be served upon Ms. Yudas so that she can duly intimate the respondent number 2 and 3. Who
Okay.
just find it out?
If they,
Affidavit not filed,
Lordship, I pray for some time, Lordship.
any time. How much time do you require?
2 weeks, Lordship.
Only?
Yes.
2 months, 2 years?
Lordship, because the instruction
Which
was.
department?
PWD, Lordship, the instruction was directly sent to the registry. The registry, and that's the reason, Lordship,
This
I.
is for non-payment.
Yes.
Yes.
List this matter for admission on 10th of September 2025. In the meantime, the respondent authorities are directed to bring on record their stand by filing their application.
Lordship, may I pray for a
you
date
are,
on the month of August, Lord,
What?
if possible? I'm praying for a date on the month of August, Lordship,
Why?
if possible, Lordship. As the payment has not been done since 3 years, Lord. Possibly. As per your convenience, Lord.
if you are,
Where is Miss M.D. Bora?
Not legal. This matter is in fact, sir.
Infrastructure, Mr. A.M. Bolgoya, the learning council appearing on behalf of the petitioner submits that the instant. Why infrastructures?
Payment is made, my lord.
Have already been received.
Yes.
Payment received.
Yes.
Mr. A.M. Bolgoya, the learning council appearing on behalf of the contempt petitioner submits that the payment have already been received by the petitioner. Pusto. Taking into account the above, comma, the instant proceedings which have been initiated alleging violation of the order dated 3/4/2024 in WPC number 5444 of 2023 stands dropped.
52,
Obliged.
Yes, complied, not complied.
Here I have filed the affidavit on behalf of the respondent number 1 today.
When?
Today, good sir.
Mr. D. Nath, the learned counsel appearing on behalf of the respondent number 1 and 2 submits that the affidavit has been filed. List of list this matter again on 15th of September 2025 along with the SEDA.
And for respondent number 1 and 3, my friend is for. I'm appealing for respondent 1 and
Only 1
and 3.
and 3. The affidavit, joint affidavit.
No, I filed the affidavit for 1. One is
File the
one is
affidavit on behalf of the respondent number 1. They.
No.
Mr. A. Solia, you want to file affidavit? Mr. A. Solia submits that he would take on obtain instructions in that matter. Mr. D. Nath further submits that he would, the learned counsel submits that he would also obtain instruction as to whether there is a requirement of any filing any affidavit on behalf of the respondent number 3. List the matter on 15th of September 2025. In the meantime, the pleadings be completed on behalf of the respondents.
54,
54 to 59, same type of order, na?
Yes, your lordship.
Which witness the review upon the anywhere. On this whole document.
Obliged.
60.
How many respondents are there? Madam, I think you can, who appears for this Assam Police Housing Corporation? Chief Engineer, Assam Police Housing Corporation, is there standing counsel? No. I think you can appear as well, no? It's a corporation.
Instruction, madam, that bigger, madam.
But here it says the service is complete.
Madam.
So the service as regards the respondents being complete as per the Lozima Court's order, list the matter for admission. Admission on 22nd of September 2025. $63.
My lord. Look, I have a simple submission in respect of item number 35, my lord. And on that matter, my lord, interim order was there, maybe continue till next date, my lord. Item 35.
The Kane Chaudhary matter,
My
na?
lord.
Interim order, what interim order? Not to take course of matter.
Till next date, my lord.
When did I fix it?
After 2 weeks, my lord. 2 weeks, my lord.
Oh, interim order, I'm not extending it.
Well, no,
No case.
earlier interim order is there.
Absolutely no case.
Till next date, my lord.
No, you have given such a long date. How am I going to have an interim order? You are not doing the math.
My lord, humbly praying, my lord, till next date, my lord, humbly
No,
praying. Otherwise, my lord,
we still have 15 minutes. Do it.
Well-
I can pass the order now only.
till next date, my
It's a
lord.
very short, precise matter.
My lord.
Even I don't require the file also, I can dictate it now. Your case is simple that look here, my ER was suspended. Within 90 days, they have not given me the show cause notice. Now they are issuing a show cause notice. My suspension is being continued. And then thereupon you have obtained a no coercive measure order. And therefore they are not in a position, you have not submitted a reply.
No, reply submitted.
My lord, we have.
Reply submitted, my lord.
Have you submitted a reply to the show cause? No.
Focus reply, my lord. During the pendency of this case, my lord, I have submitted, my lord.
You have submitted.
Submitted.
So therefore the decision should be made.
Petitioner is that he has not received the so called, my lord. And because he was avoiding receiving, my lord, the process server, my lord, when he went, my lord, he fixed the notice, my lord, so called notice in his
That is-
house in front of the, my lord, counter.
All these things are
So
disputed. my lord.
he is disputing.
Disputed, why,
All this-
226, then I'll ask him to go to the civil.
All
We have
in
to
respect of,
take it to that regard.
my lord, till next date, I am humbly praying, my lord, just for the ends of justice, my lord, till date, my lord. On that day, my lord, our case will dispose of, my lord, in accordance. Till next date.
This is not a fit case, no?
My lord,
There is,
clear, my lord. He was in police custody, he was in jail, my lord, and there is a.
no,
clear-
I am not in jail. I was in interim,
Bail,
my lord.
bail, my
Interim.
lord. Bail, a criminal
Interim.
case is pending, he's on bail, and he, my lord, misrepresentation, my lord, misappropriation of, my lord. food trace
Allegation of
and-
misapplication is there, my lord, but
Clear case.
Very bad case.
Yes, my lord.
in the,
Very bad.
And he only is
Till-
contact.
till next date, my lord, just-
The so cause, my lord. It was, my lord.
Next
he was
date can
avoiding,
be
my lord.
only on Thursday.
my lord,
This Thursday, nothing more than.
this Thursday, my lord.
Yeah, one side he about to receive, now he has a claim that I have not received.
He is not entitled. 226 no case.
Maybe, my lord, Thursday, my lord.
Hetu
Item 35.
35 to ER করবি Thursday. At mistake করবি at 2 p.m. Interim order earlier shall continue till then.
Awesome.